requesting everyone to rise for the invocation to be led by the Honorable Congresswoman Bel Zamora.
Let us put ourselves in the presence of our Lord. Gracious God, in this solemn moment, we gather as members of the Committee on Justice, conscious of the weight of our constitutional mandate and the trust reposed in us by the Filipino people. As we continue our deliberations on the impeachment complaints before this committee, grant us clarity of mind and firmness of purpose, that we may discern carefully the sufficiency and substance of the allegations presented, guided not by passion, partisanship, or personal interest, but by the Constitution, the rule of law, and the pursuit of truth. Bless our discussions with civility and mutual respect, that differing views may be expressed with reason, patience, and fairness. Grant each member the courage to vote according to conscience and conviction, mindful always of the trust reposed in us by the Filipino people. May our actions today strengthen our democratic institutions, uphold accountability, and affirm our collective commitment to justice and the common good. All these we ask in humility and hope, conscience and conviction, mindful always of the trust reposed in us by the Filipino people. May our actions today strengthen our democratic institutions, uphold accountability, and affirm our collective commitment to justice and the common good. All these we ask in humility and hope. Amen.
You may all take your seat. The meeting of the Committee on Justice is hereby called to order. Since our today's hearing is a continuation of our yesterday's hearing, we are dispensing with the calling of the roll. The Chair shall deliver her opening remarks. Good morning, esteemed colleagues, regular and ex-officio members of this committee. Today marks the third day of our proceedings. We will now hear the endorser of Maza et al. Impeachment complaint, as well as the members of the committee on the sufficiency in substance of the said impeachment complaint. Pagkatapos po nito, boboto na ang komite para sa impeachment complaint na inihain ni Attorney Andre R. De Jesus, pati na rin sa impeachment complaint na inihain ni na Lisa Maza, Teodoro Casino, Renato Reyes Jr., Attorney Nery Colmenares at 32 iba pang complainants laban kay President Ferdinand Bongbong R. Marcos Jr. Noong nakaraang Lunes, February 2, nagdesisyon ang komite na ang De Jesus impeachment complaint ay sufficient in form. Ito ay nakakuha ng 47 affirmative votes, 1 negative vote, and 1 abstention. Ganun din, idineklara nating sufficient in form ang Maza et al. Impeachment complaint sa boto na 35 affirmative, 8 negative, and 1 abstention. Malinaw ang naging pasya ng nakararami. Sapat ang forma ng mga reklamong ito upang ating ituloy ang ating pagdinig. During yesterday's meeting, the committee also voted on the motion to exclude consideration of the authenticity of the attached evidence in determining the sufficiency in substance of the De Jesus impeachment complaint. The motion was defeated with 21 members voting in favor, 24 members voting against. Accordingly, in determining the sufficiency in substance of the impeachment complaints, the committee shall likewise evaluate the authenticity of the evidence attached in support of the allegations therein. The relevant provisions of the Constitution, as well as the rules of procedure in impeachment proceedings, were also discussed during yesterday's meeting, particularly those relating to the determination of the sufficiency in substance of an impeachment complaint, as well as what will happen should an impeachment complaint be found to be both sufficient in form and substance. Significantly, for a complaint to be sufficient in substance, let us all be reminded, it must do more than suggest wrongdoing by association or inference. It must plead facts with particularity, showing that the official personally participated in, knowingly authorized, or culpably ignored acts that strike at the integrity of the office itself. Impeachment does not operate on a theory of strict liability for governance. The official is not constitutionally impeachable simply because wrongdoing is alleged somewhere in the bureaucracy or because a policy decision is later criticized or questioned. To hold otherwise would collapse the careful constitutional design and render every official perpetually vulnerable to impeachment based on suspicion alone. At the same time, the committee recognizes that impeachment exists precisely to address serious abuses of power, where a complaint alleges with clarity, specificity, and factual grounding that the official committed a grave breach of public trust. This committee has both the authority and the duty to act. Our task today is therefore disciplined, not dismissive, exacting, not adversarial. We will examine whether the allegations as written stand on constitutional ground or whether they rest on speculation, conjecture, or political disagreement dressed merely in constitutional language. Our proceeding today is intended to test the legal sufficiency of the complaint, not their popularity, not their rhetoric, not their political appeal. In doing so, this committee affirms a simple but vital principle. Impeachment must protect the Constitution, not weaken it. With that understanding, we now proceed to the inquiry on sufficiency in substance of the Maza et al. Impeachment complaint. To guide our proceeding today, we will be maintaining the ground rules, and I wish to reiterate the 6, and that is, please wait to be recognized before you speak. To begin with, we recognize the endorsers of the Maza et al. Impeachment complaint, the Honorable Tino, the Honorable Co, and the Honorable Ilago, for the manifestation of their position with regards to its sufficiency in substance. You may proceed.
Maraming salamat, Madam Chair. Sufficient in substance po ang impeachment complaint ni na complainant Lisa Maza et al. Na aming inendorso. Ayon sa ating rules, ang requirement ng sufficiency in substance ay ganito. Babasahin ko po ang rules. The requirement of substance is met if there is a recital of facts constituting the offense charged and determinative of the jurisdiction of the committee. Isa-isahin po natin ang mga elemento na yan at ipapakita na kompleto po ang complaint and therefore dapat na aprubahan ang complaint na ito batay sa sufficiency in substance. Una po, the offense charged. Sa complaint po, malinaw ang offense. Ito po ay betrayal of public trust na isa sa mga malinaw na batayan sa konstitusyon para sa impeachment, at ito ay betrayal of public trust ni Pangulong Ferdinand Bongbong Marcos Jr., impeachable official. Ano po ang betrayal of public trust? Ayon po sa konstitusyon, ito ay pagtataksil sa tiwala ng publiko o ipinagkaloob ng publiko. Ayon sa konstitusyon, public office is a public trust. Public officers and employees must at all times be accountable to the people, serve them with utmost responsibility, integrity, loyalty, and efficiency, act with patriotism and justice, and lead modest lives. No? Inilinaw pa po ng Korte Suprema sa Gonzales versus Office of the President of the Philippines. Sabi niya rito, betrayal of public trust refers to acts which are just short of being criminal but constitute gross faithlessness against public trust, tyrannical abuse of power, inexcusable negligence of duty, favoritism, and gross exercise of discretionary powers. So nakita po natin ang betrayal of public trust, hindi lang criminal act, kung hindi, sabi rito, gross exercise of discretionary power o di kaya inexcusable negligence of duty. So pwedeng may ginawa, pwedeng may hindi ginawa na maaaring maging betrayal of public trust. Okay, so ayan na po ang grounds, malinaw na nakasaad sa complaint. Ang kailangan na lang po yung recital of facts na siyang batayan ng betrayal of public trust. At malinaw na kumpleto rin po ito sa recital of facts constituting betrayal of public trust by President Ferdinand Bongbong Marcos Jr. Sa complaint po, may tatlong bahagi, tatlong parte na pinagbabatayan ng betrayal of public trust. Doon po tayo sa una. Ang una po ay itinatag, pinahintulutan at pinatupad ni Pangulong Bongbong Marcos Jr. ang isang opisyal na patakaran ng allocables at non-allocables sa pagbubuo ng DPWH budget. At ito ang naging batayan at bahagi ng isang buong sistema ng sentralisadong korupsyon na nagresulta sa tinatawag natin ngayong flood control corruption scandal. No? Ano po ang patakarang ito po? Ang patakarang ito ay nakasaad sa opisyal na dokumento o publikasyon ng DPWH nilabas ng Office of the Secretary noong July 2022 sa pinakasimula ng Bongbong Marcos Jr. presidency. Ang titulo po ng dokumento ay ang High-Level Budget Allocation Formula, the Baseline Balanced Managed or BBM Parametric Formula adopted in 2023 National Expenditure Program NEP Preparation. Yun po ang buong titulo niyan. At ang pinaka-importante po para sa diskusyon natin, kasama po o tinatakda po ng patakarang ito na ang quote, priorities of the leaders of the national government and the legislature ang isa sa magiging batayan ng pagbubuo ng NEP. No? So malinaw po, mga individual na prioridad ng mga leaders of the national government and the legislature. So tinutukoy po niyan, walang iba kundi ang mga pinakamataas na opisyal ng ehekutibo at ng lehislatura. Fact. Recitation of fact. Okay. Isa pang recitation of fact, ayon sa testimonya ni dating Yusek Bernardo ng DPWH sa Senado, sinabi niya na ang mga leaders na ito ay siyang naging mga proponent at dumaan sa proseso ng rig bidding ang mga proyekto na naipasok sa NEP at naaprubahan sa GAA at pinagbatayan ito ng mga kickback o di kaya tinatawag niyang commitment. Actually, mga advance. Ayon sa kanya, na kahit hindi pa naaprubahan, ang GAA ay binibigay na sa mga opisyal na tinatawag na proponent. Okay. So, yan po ang unang set ng mga facts na ating na nakapaloob sa complaint at pinagbabatayan ng betrayal of public trust. Nakabatay po ito sa opisyal na dokumento ng DPWH at sa public testimony, published testimony ng whistleblower na si Yusek Bernardo sa mga proceedings sa Senado. Ang pangalawang bahagi po ng recitation of facts natin ay kaugnay sa unprogrammed appropriations. Inabuso ni Pangulong Marcos ang kanyang discretion sa pagpapatupad ng unprogrammed appropriations sa 2025 General Appropriations Act. No? Ang unang abuso, sabi sa Section 35, Chapter 5, Book 6 ng Administrative Code. Sabi rito, exemptions from lump sum appropriations authorized for any purpose or for any department, office, or agency, and so on, shall be made in accordance with a special budget to be approved by the President. So that is a fact. Sabi, ang lump sum appropriations, kasama po ang unprogrammed appropriations, ay magagamit lamang sa approval ng Presidente. Fact. Another fact, sa 2023, 2024, 2025 General Appropriations Acts ay pambihira po ang naging paglobo ng unprogrammed appropriations, 807 billion, 731 billion at 363 billion in those years. No? Isa pang fact, ginamit po ng Pangulo ang kanyang discretion para aprubahan at i-release ang pondo para sa 213 billion pesos na halaga ng mga karagdagang proyekto ng DPWH. Kabilang dito ang 111 billion para sa flood control na sinabi na sa testimonya ni Yusek Bernardo ay lahat sangkot sa kickback at corruption. No? That's another fact. Another fact ay yung pagpondo ng unprogrammed appropriations. Nakasaad po sa Special Provision 1D ng 2025 General Appropriations Act para sa unprogrammed appropriations na maaaring gamitin ang mga unused reserve funds ng mga government corporations. No? Inanunsyo ng Department of Finance na gagamitin nila ang pondo partikular, ang excess reserve funds di umano ng PhilHealth para sa infrastructure projects. Tahasang labag po ito sa PhilHealth law at sa syntax law na nagsasabi na ang pondo ng PhilHealth ay para sa kalusugan lamang at hindi maaaring gamitin sa ibang mga kadahilanan. That's a fact. Naglabas po ang desisyon ang Korte Suprema. ang Pimentel versus Office of the President, at dito po ay diniklarang unconstitutional nga ang Special Provision 1D at diniklarang unconstitutional ang naging pagkuha ng pondo ng PhilHealth at paggamit nito para sa infrastructure at iba pang mga kadahilanan. Isa pang fact ay inaprubahan at hindi pinigilan ng Pangulo ang unconstitutional at illegal na pagkuha ng pondo ng PhilHealth funds. Nakabatay po ang recitation of facts na ito sa official documents, official publications, General Appropriations Acts of 2025 at ang desisyon ng Korte Suprema, Pimentel versus Office of the President. Pangatlong parte ng complaint ay kaugnay sa direktang partisipasyon ng Pangulo sa insertion at kickback. Ayon sa testimonya ng dalawa, isang Zaldico at isang Yusek Bernardo, no? Pareho corroborate po ang kanilang testimonya at sinasabi nila na direktang inutos ni Pangulong Marcos ang insertion ng at least 100 billion pesos na proyekto sa DPWH budget para sa 2025 at ayon kay Yusek Bernardo sa kanyang testimonya ay nakatanggap ng at least 8 billion pesos na pinadeliver ng Pangulo at siya mismo ang nag-deliver ng 8 billion pesos na kickback para sa Pangulo. Kaya, again, nakabatay po ito sa mga testimonya na nasa public record, particular sa mga sessions ng Kongreso, ng Senado. Okay. Kaya po, malinaw po ang recitation of facts. Lahat po ito ay bumubuo sa betrayal of public trust, no, pagtataksil sa tiwala ng bayan. At hindi po biro ang pagtataksil na ito, hindi maliit na bagay dahil ang buong flood control corruption scandal ay naganap sa buong kaalaman, pahintulot at direktang partisipasyon ni Pangulong Ferdinand Bongbong Marcos mismo. Yan ay betrayal of public trust, dapat siyang ma-impeach. Sufficient in substance po ang complaint. Maraming salamat po, Madam Chair.
Does that complete your manifestation, Honorable Tino?
Yes, Madam Chair.
Thank you. Now we recognize the Honorable Ko.
Thank you, Madam Chair. Madam Chair, mga kapwa ko mambabatas at sa sambayan ng Pilipinong nakasubaybay, isang makatarungang pagbati sa ating lahat. Ayon sa Rule 3, Section 5 ng Rules of Procedure and Impeachment Proceedings ng ika-20 Kongreso, masasabing sapat ang nilalaman ng complaint kung mayroon itong una, recital of facts na nagpapakita na ang usaping nakalatag ay saklaw ng otoridad ng House Committee on Justice. At ikalawa, kung may recital of facts na nagsasaad sa mga ginawa o hindi ginawa ng akusado na nagresulta sa isang offense, or in this case, ang pagtataksil sa tiwala sa publiko o betrayal of public trust. Kaya naman po, Madam Chair, pinaninindigan namin na itong ikalawang impeachment complaint na inihain ni Maza at iba pa laban kay Pangulong Ferdinand Marcos Jr. ay sufficient in substance. Hindi maitatanggi na pasado ang impeachment complaint na ito sa dalawang nabanggit na pamantayan. Una, tungkol sa recital of facts na nakakasaklaw sa jurisdiction of the Committee on Justice ang impeachment complaint na ito, matatagpuan ito sa paragraphs 1 and 2 ng impeachment complaint. Pangalawa, ang recital of facts na nagpapakita ng mga paglabag ng Pangulo, partikular sa tiwala ng publiko, na inaakusa sa complaint na ito ay makikita sa bahaging Statement of Facts at Discussion. To refresh lang din po, the impeachment grounds include betrayal of public trust. And this standard is read alongside the declaration in the 1987 Constitution, particular po, Article 11, Section 1, which states, public office is a public trust. Public officers and employees must at all times be accountable to the people, serve them with utmost responsibility, integrity, loyalty, and efficiency, act with patriotism and justice, and lead modest lives. Nakasaad din po sa kasong Gonzales III versus Office of the President of the Philippines ang isang appreciation kung ano ang sinasaklaw ng betrayal of public trust. Ito ay mag-include ng acts which are just short of being criminal but constitute gross faithlessness against public trust, tyrannical abuse of power, inexcusable negligence of duty, favoritism, and gross exercise of discretionary powers. So maari po itong less than criminal but must be attended by bad faith and of such gravity and seriousness as the other grounds for impeachment. At inonote lang din po, hindi ibig sabihin na itong mga naka-enumerate, ito na po yung nilalaman ng betrayal of public trust. Pero ito ay ilustrasyon kung anong pwedeng nakapailalim ng betrayal of public trust. At dapat may standard nga na may bad faith and of gravity and seriousness. Kaya naman po muli, the complainants and we the endorsers find 3 acts that fall under this definition. Number 1, President Marcos Jr. adopted, implemented, and institutionalized a systematic scheme of corruption gamit ang tinatawag na baseline, balanced, managed, parametric formula as the official allocation mechanism for flood control and other infrastructure projects, thereby converting the national infrastructure budget into a centralized apparatus for plunder. Sa isang dokumentong nirelease ng DPWH Office of the Secretary na kapetsa ng July 2022, nakasaad doon na ang BBM parametric formula ay ginamit para i-prepare ang 2023 National Expenditure Program, kung saan ang managed portion ng formula ay may clause na nagsasabi na, and I quote, priorities of the leaders of the national government and the legislature will also be considered in the matter of infrastructure budgetary allocations, which allowed ang technical flood risk data ay ma-override ng priorities na ito at nagresulta sa paglustay ng pera ng taong bayan para magtayo ng mga proyekto sa area na di kailanman at di angkop sa lugar na kinatayuan para lang may makuhang kickback ang mga opisyal at kontraktor. Ang formula na ito ay hindi lang nakapangalan or nakapalayaw sa acronym ng Pangulo na BBM, pero siguradong dumaan din sa mata ni Pangulong Marcos Jr. at pinangasiwaan taon-taon. Meron pa nga pong declaration, Madam Chair, si incumbent DPWH Secretary Vince Dizon that they will phase out the Cabral formula in the future NEP preparations. Pumaldo dahil pinadulas ng DPWH sa ilalim ng Pangulo ang sistema ng nakawan na nakatago mismo sa proseso sa pagbabudget ng pondo ng bayan. Nakakasira sa tiwala ng Pangulo, ng publiko, ang pag-imbento ng isang modus operandi na nagbibigay daan sa nakawan sa kaban ng bayan. This is an impeachable offense. Number 2, President Marcos Jr. personally authorized the 213.8 billion pesos in unprogrammed appropriations releases from 2022 to 2025, which funded anomalous projects. Ito ay isang grave abuse of discretionary power na nakabigay sa Presidente under the Administrative Code and the General Appropriations Act ng 2024. Gusto ko lang pong i-cite kung anong nakalagay sa Administrative Code. Section 35, Chapter 5, Book 6 of this code mandates expenditures from lump sum appropriations authorized for any purpose, for any department, office, in any General Appropriations Act shall be made in accordance with the special budget to be approved by the President. Ito rin po ay nakasaad sa Special Provision Number 1 ng 2024 GAA under UA explicitly providing that ang release ng UA ay subject to the submission of a request to the President and a special budget to be approved by the President pursuant to Section 35 of the Administrative Code. Wala pong lusot. Nakasaad sa mga binanggit nating probisyon sa batas na nasa Pangulo ang huling pasya para gastusin ang unprogrammed appropriations. Mas malala pa kaysa sa bastang-bastang paglipat ng Pangulo ng pondo para sa mga kaduda-dudang flood control projects, ginamit din ang parehong Special Provision number 1 ng 2024 GAA para utusan ang PhilHealth na magsoli ng 89.9 billion pesos sa National Treasury, na inaming ginamit din para pondohan ang unprogrammed appropriations para raw sa infrastructure projects na di malinaw at di masilip ng lehislatura bilang sila ay nasa unprogrammed appropriations. Kaya naman po, ito ay actually dineclare ng Korte Suprema just this December 2025 na labag sa konstitusyon. Dapat ang Pangulo ay kayang pagkatiwalaan sa paggawa ng mga desisyon para sa kapakanan ng bayan, pero nakakasira ng tiwala ang pag-abuso niya sa paglipat pondo at paggastos para sa unprogrammed appropriations sa mga proyekto na di na nga mabusisi sa transparent na talakayan sa Kongreso at maanomalya pa. Imposibleng di dumaan sa Malacanang ang mga desisyon sa paggamit ng UA. Direktang pananagutan niya ito at hanggang ngayon wala pa ring buong paliwanag sa pinagdalhan ng pera na ito. Pagbasag po ito sa tiwala ng publiko and thus an impeachable offense. At number 3, si President Marcos Jr. ay direktang nag-utos ng budgetary insertions na di bababa sa 100 bilyong piso. Direkta rin daw na nakinabang siya sa di bababa na 8 bilyong piso na ipinadala sa mga tauhan niya. Ito, kung napatunayang totoo, ang pinakamabigat sa lahat. Kailangan ungkatin to para mapatunayan sa dulo kung karapat-dapat pa bang makuha ng Pangulo ang tiwala ng publiko sa kabila ng lahat ng mga nagawa at di nagawa para masira ang tiwalang ito. Walang dahilan para hindi po tumuloy ang complaint na ito sa susunod na yugto ng proseso. The clear recital of facts constituting the offense is provided in the complaint. Kaya naman, Madam Chair, mga kapwa ko mambabatas, sa ngalan ng kabataan, nais kong ipaalala na ang pangalan ng ating komite ay Committee on Justice, na nanawagan ang taong bayan ng hustisya. Nanonood din at nakabantay ang kabataan, much like nung mas bata po ako, ay nakaabang tayo sa mga iba't ibang proseso na nakabinbin para itry ang mga publiko. Kaya naman kami handang ipaglaban ang katarungan at pananagutan, anuman ang maging pasya ng kapulungang ito. Thank you, Madam Chair.
Thank you, Honorable Ko. Now we will hear the manifestation of position of the Honorable Ilago.
Madam Chair, ang verified impeachment complaint laban kay Pangulong Ferdinand Marcos Jr. na inendorso ng representasyon na ito ay may malakas at sapat na batayan. Ito ay naglalahad ng 3 malinaw na paglabag na nagpapakita ng pagtataksil sa tiwala ng taong bayan. Una, ang pagpapatupad ng baseline balance managed parametric formula na may basbas ng Pangulo sa paggawa ng pambansang budget. Ginawa itong paraan para gawing lehitimo at nasa disenyo mismo ang political patronage at corruption. Sinasabi mismo sa formula na isa sa alang-alang nito ang priorities of leaders. Ibig sabihin, ang pambansang budget ay hindi naaayon sa pangangailangan ng mamamayan. Hindi po iyon ang nauuna, kundi ang nauuna ay yung gusto ng mga nasa kapangyarihan. Pangalawa, ang pag-abuso sa presidential discretionary powers sa unprogrammed appropriations. Bilyon-bilyon, lalo na ang 89.9 billion pesos mula sa pondo ng PhilHealth na para sana sa kalusugan ng mga may hirap at mga nangangailangan ay ginamit sa mga proyektong may anomalies tulad ng mga flood control na overpriced o ghost projects. Ang Pangulo at tanging ang Pangulo lamang mismo ang may kapangyarihan na tuluyang mag-authorize ng release ng 213 billion pesos na unprogrammed appropriations na naging balon ng malawakang korupsyon. Kaya ito ay malinaw na pagtataksil sa tiwala ng taong bayan. At pangatlo, Madam Chair, ang complaint ay nagsasabi na direktang kasangkot mismo ang Pangulo sa sistema ng mga insertions at kickback sa budget. Ang tatlong akto na ito ay seryoso at magkakaugnay. Ang mga ito ay nagpapakita ng isang sistema at disenyo ng pangungurakot sa ilalim ng kasalukuyang administrasyon. Ang mga gawaing ito ay sakop ng malawak na batayan ng betrayal of public trust. At ito ay usapin na pangunahing nakakapudpod ng integridad sa pinakamataas na posisyon at opisina dito sa ating bayan. Kaya't naninindigan kami, ang impeachment complaint na ito ay may sapat na substansya. Ang trabaho ngayon ng komite na ito ay kilalanin na nararapat itong imbestigahan at magkaroon tayo ng hearing kung saan malalantad pa ang katotohanan at magkaroon ng tunay na pananagutan. Dapat kilalanin ang batayan ng reklamong ito, nararapat na dinggin ang hinaing ng taong bayan. Sapat na ang batayan, dapat na itong aksyonan. Maraming salamat.
Thank you, Honorable Elago. That completes the manifestation of position of the endorsers of Maza et al. Impeachment complaint. At this juncture, we are eliciting the comments, opinion, positions of the members of the committee with respect to the sufficiency in substance of Maza et al. Complaint.
Madam Chair,
Madam Chair.
The Honorable Lagbas, then Honorable Erice.
Thank you, Madam Chair. I would just like to manifest some of my observations on the first allegation in the Maza complaint. It's about the BBM parametric formula. While the allegation is grounded upon a paper proposing the adoption of BBM parametric formula, the statement shows that the same is created by DPWH. There is no allegation or statement showing any administrative order, memo, executive order, or any directive executed by the President himself. Secondly, even the statements on alleged kickbacks, Madam Chair, actually, the complaint pertains solely on alleged kickbacks involving DPWH officials and certain legislators and does not show any participation, knowledge, or consent on the part of the President. That's just my observation on the first allegation, Madam Chair.
The Honorable Erice.
Madam Chair, good morning. Matapos kong masusing suriin ang impeachment complaint na inihain nila Lisa Largosa Maza et al. Laban kay Respondent President Ferdinand Marcos Jr., malinaw sa akin na ang reklamo ay sufficient in substance. Batay sa pamantayan ng prima facie sufficiency. Linawin natin, hindi pa natin hahatulan ang Pangulo. Ang tanong lamang ngayon na ito, kung mapapatunayang totoo ba ang aligasyon, may nagawang impeachable offense ba ang Pangulo? Ang sagot, oo. Ang reklamo ay hindi puro opinyon o konklusyon. May malinaw, tiyak at verifikableng mga katotohanan. Isang malinaw na halimbawa, ang malubhang kapabayaan ng Pangulo sa pagpayag na salaulain ang pambansang budget ng kanyang mga kaalyado. Daan-daang bilyong piso ayon mismo sa reklamo. Pinayagan ang insertions, diversions at manipulasyon. At sa kabila nito, nilagdaan at ipinatupad ang paglalabas ng mga pondong ito. Ayon sa reklamo, pinahintulutan at nilaglaan ng Pangulo ang paglalabas ng bilyong pisong unprogrammed appropriations, mga pondong walang tiyak na pinanggagalingan na ginamit umano sa ghost projects, substandard infrastructure projects, at maanumalyang flood control. Hindi ito simpleng pagkukulang. Ito ay systematic acts na tuwirang pumapasok sa betrayal of public trust. Ang reklamo rin ay malinaw na nagsasaad na pinayagan ng Pangulo ang paggamit at pag-divert ng pondo mula sa PhilHealth, PDIC at foreign assisted projects appropriations na nagdulot ng malalaking pagkaantala sa mga flagship projects ng ating bansa. Metro Manila Subway, PNR Elevated Rail at iba pa. Ang epekto nito, bilyong-bilyong pisong nawala dahil sa commitment fees, penalties at price escalation. Ito ay tunay na perang nawala, tunay na oportunidad na nasayang at tunay na pasaning ipinapataw sa mamamayang Pilipino. Ang reklamo ay malinaw na sumasagot sa mga batayang tanong. Sino ang gumawa? Ang Pangulo. Ano ang ginawa? Pinayagan at nilagdaan ng budget, manipulation at anomalous releases. Kailan? 2023, 2024 at 2025 GAA. Paano? Sa pag-aproba ng releases at kabiguang pigilan ang diversion ng pondo. Higit sa lahat, may direktang ugnayan ang mga gawain ito sa impeachable offense na betrayal of public trust. Ang mga aligasyon ay grabe. Tinatamaan ang public interest, sinisira ang constitutional order at winawasak ang tiwala ng mamamayan sa pamahalaan. Kung mapapatunayang totoo ang mga ito, may nagawang impeachable offense ang Pangulo. Iyan lang ang dapat nating pagpasyahan sa yugtong ito. Dapat bigyan ng pagkakataon ang mga nagrereklamo na magharap ng mga ebidensya, magsumite ng mga sworn statements at mapatunayan ang kanilang mga aligasyon. Kasabay nito, dapat ding bigyan ng pagkakataon ng Pangulo na ipagtanggol niya ang kanyang sarili. Ito ay hindi pag-uusig. Ito ay due process. Ito ay hustisya para sa nagrereklamo, para sa Pangulo, at higit sa lahat, para sa mamamayang Pilipino na may karapatang malaman, pinabayaan ba? May ginawa bang kasalanan? Pinagnakawan ba tayo? Kapag pinatay ang investigasyon, kung pipigilan ng komiting ito ang pag-usad ng investigasyon, ang magiging imahe ng Kamara ay may pinagtatakpan. Lalo na't maraming mambabatas ang di umano'y nakinabang. Maraming distrito ang biglang nagkaroon ng mga bilyong-bilyong alokasyon. At marami sa mga ito ay napunta sa mga flood control projects. Kung pipigilan natin ito, baka tayo mismo ay husgahan ng bayan bilang kasabwat sa pagtatakip sa katotohanan. Lalo pang magpapabagsak sa tiwala sa gobyerno, magpapahina ng ekonomiya, magpapalayas ng investors, magpapawala ng trabaho at magpapalalim ng kahirapan. At sa susunod na tagulan, sa bawat baha, sa bawat dilubyo, sa bawat buhay na malalagas, tayo ang sisingilin ng mamamayan. Madam Chair, hindi natin dapat katakutan ang katotohanan. Ang dapat natin katakutan ay ang pagtatakip dito. Payagan nating umusad ang investigasyon, hindi para sa Pangulo, hindi para sa atin, kundi para ipagtanggol ang konstitusyon ng Republika. Maraming salamat po.
Madam Chair. Thank you, Honorable Eriza. Before we proceed, please let the Chair read the 3 specific grounds for impeachment. First, under the first act of betrayal of public trust, institutionalizing systemic corruption through the BBM parametric formula of allocables.
Clarify.
Second act of betrayal of public trust, abuse of discretionary power over unprogrammed appropriations. And third act of betrayal of public trust, direct personal involvement in budgetary insertions and kickback schemes. For uniformity, since we deliberate on the sufficiency in substance, with respect to the De Jesus complaint per ground, we will be following the same system. So we are reminding the members to please confine the manifestation on the first ground first, and that is institutionalizing systemic corruption through the BBM parametric formula of allocables. That is for the guidance of the members. The Honorable Zamora.
Pwede ka nang...
Madam Chair, if I may make my manifestation as regards the entire complaint. Yesterday, it was made clear that for an impeachment complaint to be declared sufficient in substance, the recital of facts should constitute the impeachable offense charged. It is clear that we need to show the ultimate facts or the overt acts of the President in relation to the various schemes he allegedly perpetrated. The second complaint shows 3 different schemes. In brief, they are institutionalizing systemic corruption through the BBM parametric formula, abuse of discretionary power as regards on program appropriations, and direct personal involvement in kickbacks. These 3, in fact, are interconnected. It is all about the flood control scheme. I don't want to belabor the point, Madam Chair. It is clear from the complaint that the President did not do any overt act that will show that he directed these 3 schemes. In the first place, it was not the President who created the BBM parametric formula of the DPWH. Having an imperfect policy direction is not an impeachable offense. Second, that the Supreme Court struck down the provision relating to PhilHealth funds does not make the President primarily liable for such. The connection to corruption is highly speculative. Finally, that the President allegedly has a direct personal involvement is not clear from the allegations or borne out from the records. We should not tolerate the use of hearsay allegations, videos that are not attested to, or fake news. The Honorable De Lima yesterday repeatedly said that there should be a nexus between the specific acts and the impeachable offense charged, and I fully agree. Accusations are not factual allegations. A lot of what is written are mere speculations or conjectures arising from hearsay and worse, even double hearsay testimonies, just to connect the President to the charges. To say that the office of the President has become the command center of a criminal enterprise is not only unfounded, but is also a mere dramatic rhetoric. Thank you, Madam Chair.
Thank you. Next, we recognize the Honorable Garbin.
Thank you, Madam Chair.
Madam Chair, may I also be recognized later on?
Honorable Garbin, then Honorable Gonzalez, then Honorable Abante, one after the other. Thank you.
Madam Chair, also, this representation, I've been raising my hands early on.
Okay, let me repeat. Honorable Garbin, and then Honorable De Lima, Vice Chair Dumogan, Honorable Gonzalez, and then Honorable Abante. And then Honorable Rodriguez. Thank you, Madam Chair. Thank you. You may proceed, Honorable Garbin.
Thank you, Madam Chair. On the first ground, the BBM parametric formula as an institutionalization of corruption. The core allegations of the complainant is that the DPWH approach or the baseline balance manage allegedly shows priorities of leaders to override technical allocations and branding it BBM, and it proves as a presidential corruption framework. Let me state, Madam Chair, that this is not sufficient in substance. Number one, a planning allocation formula is not illegal on its face. Government budgeting necessarily involves policy priorities. The phrase priorities of leaders, even if quoted, is not proof of craft. It is consistent with political accountability in appropriations, especially where Congress itself sets national priorities. The complaint does not cite a constitutional provision prohibiting executive consideration of policy priorities in infrastructure programming. Second, no pleaded fact shows that the President authored, ordered, or used the formula to commit a corrupt act. The complaint infers presidential culpability from branding BBM and from the existence of managed stage. That is not ultimate facts, Madam Chair. It is an argument. Third, no annex authentic DPWH document is shown in the filed copy. the complaint quotes and footnote sources, but the filed copy provided does not attach the complete DPWH policy issuance as a certified annex for committee verification. Without the annexes, the committee is being asked to accept the complainant's characterization rather than reviewing the underlying document. So my take on this, Madam Chair, is at most this pleads a policy critic. It does not plead an impeachable offense nor a willful constitutional breach. Thank you, Madam Chair.
Thank you.
Madam Chair,
The Honorable Tino.
yes, this is just with regard to the observation of the Honorable Garbin that...
You may
that-
proceed.
Thank you. That the observation of the Honorable Garbin that the complaint was submitted without annexes for the information of the committee, if it is not yet aware, the complaint was submitted with annexes in a USB format and it was sealed by, in an envelope by the Secretary General or the Office of the Secretary General when it was received. And among the annexes is the complete document of the BBM parametric formula, among others. No, so let me correct that wrong information that there are no annexes. There were annexes officially submitted, and we hope that the committee will provide the annexes to the members themselves for their appreciation. Thank you, Madam Chair.
The committee notes of the manifestation of the Honorable Tino with respect to the submission of the said annexes. Next to manifest is the Honorable De Lima.
Thank you, Madam Chair. Good morning to my colleagues. Before I comment on the first ground of the Maza et al. Complaint, I just wish to state that the first two speakers, the two members who first spoke earlier, actually dwelled already on the entirety of the complaint. So it's good for the Honorable Chair to clarify that we are tackling at this point the first ground. Second po, kailangan rin po malinawan, the Honorable Chair stated yesterday very clearly that in the course of our voting, the Honorable Chair said, the committee would vote on the entirety of the complaint, but not on the specific allegations. Tama po yun. I agree na dapat ganun po ang tingin natin later kapag narinig na natin lahat tungkol sa three allegations. Three factual allegations supporting the general ground of betrayal of public trust. Kasi yung first act of betrayal of public trust, second act, and then the third act. Ganun po. Kasi nga po, baka po meron ilan sa atin ang tingin sa isa ay sa isa may mga certain allegations na hindi naman talaga ultimate facts, but more of conclusion already. But whether or not that's the case, ang importante, ang analysis po natin ng buong complaint is that it would show that there is sufficiency in substance in the sense that there is a recital of the acts constituting the offense charge. So may I proceed, Madam Chair, sa aking analysis po?
You may proceed, Honorable De Lima.
Ng first factual ground, betrayal of public trust. First act, institutionalizing systemic corruption through the BBM parameters formula of allocables. At just like po yung pag-analyze ko po kahapon doon sa first or the De Jesus complaint, meron po ako mga nakita na mga ilan-ilan, or I need to point out ilan-ilan na mga sub-allegations. The first one, DPWH adopted BBM parametric formula for allocating 545.6 billion in flood control appropriations for 2022 to 25. As a result, UA exploded, that's the unprogrammed appropriations, exploded from 251.6 billion in 2022 to 807.2 billion in 2023. I consider this, Madam Chair, a sufficient factual allegation. I will say later my general comment on this, on the first ground. The second sub-allegation, the managed stage of the parametric formula admits that political patronage determine allocation of funds. To me, this is a conclusion derived from the language of the PBBM parametric formula and not a factual allegation. Third, contractor testimony confirms the BBM parametric formula as a kickback scheme where DPWH officials demanded 10 to 25% and congressmen 25% paid in cash. This is an allegation sufficient as to the fact of kickbacks. Again, may I just emphasize po, pag sinabing allegation, allegation lang on the face of the complaint. Na kapag paniniwalaan natin, which is not necessarily true or will turn out to be not necessarily true, ay sufficient na. Yun po ang ating standard at this point. Meron ho kasi mga nalilito na sa pag-discuss nitong very issue of sufficiency of substance ay kailangan ng delve na kaagad doon sa meron bang ebidensya, tama ba yung ebidensya. Hindi po yun ang tinitingnan natin, at least at this point. I must say that, Madam Chair, because upon review of the rules of procedure, etong sa atin ngayon is just really on the sufficiency in form and substance. There is, and then subsequently, meron din nakalagay sa rules of procedure na kapag halimbawa we find the complaint as sufficient in both form and substance, papasagutin na natin yung respondent, and then pwedeng mag-comment mag-reply yung complainant, and then pwede rin mag-rejoinder yung respondent. At pwede rin silang mag-attach ng mga affidavits and other evidence dyan sa mga pleadings na ating i-require or the rules require sa kanila. Pagkatapos pong nandyan na yan lahat na pleadings, lahat ng mga supporting documents, if any, including affidavits, there is another stage po dito sa committee, dito sa ating committee, sa committee level. At yan po ay to determine whether the complaint alleges sufficient grounds for impeachment. So separate pa po pala yung pag-determine natin o pag-decide kung ito ba ay sufficient grounds bago magkaroon ng evidentiary hearing kapag the committee's finding is in favor of sufficient grounds. Yun po ang aking pagkakaintindi, kaya ka po linilinaw po ito lahat. That's why my analysis, as you can observe, is focused really on that, the sufficiency of allegations. Another sub-allegation po, going back po sa analysis ko po. Contractor testimony confirms the BBM parametric formula as a kickback scheme where DPWH officials demanded, nasabi ko na po pala ito, demanded 10 to 25% and congressmen 25% paid in cash. Allegations sufficient as to fact of kickbacks, but remains a conclusion as to parametric formula as the cause. Conclusion po yan. Pero meron factual allegation. Another, managed stage of parametric formula, cost award of 1/5 of 545.6 billion to 15 contractors / favored entities. Again, I see this as allegation sufficient as to fact of award, but is a conclusion as to parametric formula as the cause. Yung factual allegation, meron ng conclusion. But does it defeat the existence of the factual allegation? Does it mean na wala ng factual allegation? Hindi ko ganun ang conclusion natin. Meron factual allegations, meron lang conclusion na nakahalo. Next, parametric formula caused geographic distortion of flood control projects into dumping grounds without master plans. Again, sufficient as to the fact of geographic distortion. Again, allegational lang po. Hindi ko sinasabing yan na yan. Totoo na yan. But is a conclusion as to parametric formula as the cause. Another, parametric formula as designed to facilitate corruption was deliberate. Para sa akin po, conclusion na po ito, not a specific factual allegation. Doon naman po, the last factual point that I need to show, parametric formula centralized and syndicated system of plunder, enriching PBBM, the cabinet, and Congress leaders. Again, this is a conclusion, not a specific factual allegation. In general, for the first ground, I find the specific factual allegations, even without the conclusive statements derived from them, actually establish a probable nexus. So merong specific factual allegations, may kasamang conclusions. In the end, it's still established for me. The nexus is there. Establish a probable nexus. That's for the first ground, Madam Chair. Sufficient.
Honorable De Lima, does that complete your manifestation for the first ground?
For the first ground, Madam Chair.
Can we finish first all the manifestations for the first ground before we call you for the succeeding grounds?
Yes po.
Thank
First
you.
ground.
Now we recognize the Honorable Vice Chair Dumogan. Again, this is for the first act of betrayal of public trust on the BBM parametric formula of allocables.
Thank you, Madam Chair. First, the complainants had verified that they have factual knowledge of the allegations as it is coming out. The allegations from paragraphs 5 to 65 do not show that they have factual knowledge. It's based on second information. I do not like to belabor on that point. I do not like to repeat what our distinguished colleague De Lima had stated. Yes, it can be if there is a factual allegations, but it does not link the President, because what we are obligated to find out is sufficiency in substance that will link the President, that will justify the prosecution of the President on an impeachable offense. It will be prolonging the agony if we will just keep on admitting this and go to the steps if we know from the documents and from the allegations submitted that there is no direct allegations and evidence that can link the President for the commission of legal infraction which is interpreted as impeachable offense under our Constitution. I had reviewed the allegations paragraphs per paragraph, and it is my humble submission that on ground number 1, institutionalizing system corruption through the BBM parametric formula, I cannot find evidence that will directly link the President for having committed an impeachable offense. Yes, we condemn corruption that has been committed. I am sure that all of us are to that point. But our function is to determine whether there is an impeachable offense in the determination of sufficiency in substance that should justify the continuation of the proceedings that will reach the impeachment trial, which at this point on time, on this first ground, as I said, I respectfully submit that I cannot find one. I do not like to say it one by one. My justifications on this point because of limited time. But if it is necessary, then by all means, we will do it. I respectfully submit.
We commend Vice Chair Dumogan for reading paragraph 5 to 65. Moving on, we recognize the Honorable Mika Gonzalez.
Thank you, Madam Chair. Madam Chair, I would like to respectfully manifest to this honorable committee that the impeachment complaint filed by Lisa Maza et al. And endorsed by the Makabayan Bloc is insufficient in substance due to lack of personal knowledge and authentic records. There is zero evidence, documentation, or allegation in the complaint to show that President Marcos authored, participated, or even issued any marching orders for the implementation of the baseline balance managed parametric formula. The complaint is flawed due to the absence of any affidavit of witnesses with personal knowledge and authentic records of the alleged acts. Furthermore, the mere existence of a parametric formula alone fails to meet the threshold of an impeachable offense under the Constitution. In addition, Madam Chair, the complaint fails to provide a recital of facts explaining how President Bongbong Marcos institutionalized or participated in a systematic scheme of corruption through the baseline balance managed parametric formula. The President's specific role was never disclosed or included in the allegations. That's all, Madam Chair.
Thank you, Honorable Gonzalez. Now we move to the Honorable Benny Abante.
Thank you, Madam Chair. I'm so glad that Congressman Risa is here so that I could be able to somehow answer some of the comments he made, no? But first of all, I'd like to commend the chairman of the Committee on Justice. Ako, gusto ko nang i-close to eh. Pero the thing is, the chairman of the Committee on Justice would like to, yung himayin po niya ang kasong ito. Oo. Para hindi naman tayo sabihin ng taong bayan na minamadali po natin ito. So I really would like to commend the chairman of the Committee on Justice in being fair in doing this. Oh, hindi ko po kinukuha yung suporta niya. Ngayon ito. Before I go to the sufficiency of substance, hindi po ako abogado. Pero nagbabasa rin po ako eh. Di ba? O ito, there are some controlling doctrines and legal basis. Yan legal basis, no? When the issue concerns sufficiency in substance. Ayan. Number one, an impeachment complaint. Tapos paniniwala ko, is sufficient in substance when it alleges specific ultimate facts. Ayan, ang pagkakaalam ko. Bilang nandito po ako sa Kongreso for the past 15 years. Okay? Which if assumed true, constitute an impeachment offense. For example, like culpable violation of the Constitution, or treason, or bribery, graft and corruption, or other high crimes, or betrayal of public trust. Number two, I'm not trying to lecture you on law. Ito lang po yung narinig ko, nabasa ko, naintindihan ko. Alright? The following must be present. For example, like identification of the respondent as an impeachable officer. In-identify niya ang Pangulo ng Pilipinas, for example, or VP, or Supreme Court Justice, whatever it is, or specific acts or omissions alleged, not conclusions, like betrayal of public trust is standing alone. Ayan. O, number 3, a clear link between the acts and a constitutional impeachable ground. Facts that show how the acts amount to, for example, bribery, graft, culpable violation of the Constitution, nangyari. Oh, number 4, the time, the place, the context, and the participation. Who did what? When? Where? How? Enough for the respondent to understand the charge and for the committee to assess whether the ground is facially present. Ayan. O, number 5, not mere general allegations. Kaya po ako nung isang araw, medyo nag-walk out na kasi puro mere allegations na narinig ko eh. Hindi naman pinapaliwanag sa atin kung ano yung sufficient inform. Alright. Ito ngayon, not mere general allegations. Now, we can accept allegations here, pero it must be based on evidence. Hindi lang po allegation po ito. Oh, the court has stressed. Nalaman ko lang, naintindihan ko. The court has stressed that, I quote, ang sabi, mere allegation is not evidence. End of quote. Now, the House substance requirement is met only if there is, as I understand, and I quote, a recital of facts constituting the offense charge and determinative of the jurisdiction of the committee. Ayan. Yan po ang sabi sa Gutierrez versus House of Representatives Committee on Justice. Et al. GR number 193459, February 15, 2011. Parang na akong abogado rito. Nagsasite na ako ng jurisprudence. Ito. Number 4, when corruption, for example, is invoked as an impeachment ground, it, as I would quote someone else who is a legal luminary, saying, must be supported by more than bare allegations. End of quote. An impeachment, must be exercised with, yun po yung sinabi ng kaibigan ko, si Congressman Rizzi, due process. Ito pong ating ginagawa ngayon, in fairness with the chairman of the Committee on Justice, na sa akin po dapat nang tapusin ito Due process po ang kanyang sinasabi dito. And what? And fairness. Sa akin po, hindi na fair sa amin Fair na po doon sa mga endorsers ng impeachment process na ito Fair na po yan sa inyo ito. Gusto ko na pong banggitin yung issue number 1, no? Issue number 1. Yung tinatawag nating BBM parametric formula na binanggit ng dating Secretary Bunuan. Di ba? Yun ang sabi niya. Sa akin po, hindi sufficient in substance po ito and should be dismissed as the initiatory state for failure to what? To plead facts constituting an impeachable offense as an act or omission of the respondent. Hindi naman po na ipaliwanag yung tinatawag nating BBM parametric formula. Whether it be explained by the former secretary or even explained by the complainants themselves. Na nakalagay po dito. Ito po sabi nila, an indictment of a policy framework. Na gusto ko pong sabihin dito, sufficiency in substance turns out whether the complaint recites facts constituting the charged offense. Not rhetoric, not labels, or even policy disagreement. Dapat ito po ay talagang facts. O yun lang po muna. Yun po yung una kong gusto kong sabihin at meron pang kasunod yan. At gusto ko ipangako sa ating Madam Chair, hindi po ako magwo-walk out this time.
Thank you for your passionate
Madam Chair.
manifestation. In response to the manifestation of the Honorable Abante,
Yes, Madam Chair.
the Honorable Ko is recognized.
Thank you, Madam Chair. Just quickly responding to the previous manifestation, any jurisprudence that cites that yung complaint has to be supported by more than mere allegations or bare allegations. Dahil yan ay galing sa decision ng the Supreme Court, ibig sabihin dumaan na po yan sa trial stage at nahanap sa trial na walang evidence. Pero to reiterate, wala pa po tayo doon. Nasa stage pa lang po tayo ng determination of sufficiency of substance. Kung ang allegation sa complaint, if you take it one by one or the whole, would constitute an impeachable offense. So, meron pa rin talagang pag-deem na hypothetical admissions ang ginagawa natin, granting na totoo yung lahat ng mga sinabi ng complaint, meron bang betrayal of public trust na nagaganap? Once again, to remind lang po the committee and the body na nandun pa lang po tayo, hindi pa po tayo pumapasok dun sa pagsiyasat, the truth of the allegations. And anyway, kaya naman po hinahain dito dahil may confidence yung complainants na kapag we delve into that and we're able to present evidence and we're able to call on witnesses, they're able to submit affidavits, meron pong truth na malalabas. Madam Chair.
Thank you. The manifestation or response of the Honorable Ko is noted.
Madam Chair, since nabanggit po yung pangalan ko,
The Honorable
I think-
Erize.
Yes, gusto ko lang po, very, very short. Gusto pong liwanagin na wala pa tayo sa stage ng pagpipresenta ng ebidensya na tulad ng sinabi ni Congressman Abante. At yung pong mga sinabi niya na parameters para sa determination ng prima facie ay lahat po binanggit ko. Who? Presidente. What? Yung pong pag-aproba niya ng release ng mga unprogrammed appropriations at pagpayag niya na tanggalin yung mga flagship projects na nagresulta sa pagkalugi ng gobyerno. Pangatlo, when? 2023, 2024, at 2025 national budget. How? Ayun po, yung pagpirma niya. Yun yung importante. At 3 taon. Kaya po, ma-relink natin ito sa isang paglabag, kung tatawagin ko po ito, inexcusable gross negligence. Matinding pagpapabaya. At ito po na particular na offense na ito ay pumapatak sa betrayal of public trust. Yun lang po. Salamat po.
The manifestation is noted. At this juncture, we recognize the Honorable Rufus Rodriguez.
Thank you, Madam Chair. Specifically, the first act or the first ground to impeach the President is under page 18. Charge, paragraph 66. Respondent President Marcos betrayed public trust by institutionalizing a scheme of corruption through the baseline balance parametric formula. That is the charge. That's not the recital of fact. That's the charge. So I expected, that after 66, there will be recital of facts that will be able to state in ultimate facts the acts of the President institutionalizing the BBM formula. This is from page 18 to page 23. A clear reading of all the paragraphs here does not even an iota of recital of fact that there is a connection. There is an act of the President to institute this particular formula. How will the President institute something in this country? Administrative Code of 1986. It says the President issues. presidential proclamations, executive orders, memorandum circular. There is no recital of fact here that the President has issued such orders are provided for in the Administrative Code of 1986 that institutionalizes the BBM formula. Second, it can be done through indirectly. There is no recital of fact here that the President called officials of the Public Works of Malacanang to tell them to institute this formula. Nothing recital of fact that the President did the act of institutionalizing under the Administrative Code or even indirectly. No recital of fact on that. Now let us go to the particulars. These are now their alleged recital of facts. Page 18, 67 paragraphs. Paragraph 67. About July 2022, with the first month of assuming the presidency, the DPWH adopted, that is their statement, adopted the BBM parametric formula. Because indeed, the Department of Public Works originated, planned, discussed, implemented this formula. Where is the President here? In the planning, in the implementation. No, there is no statement here that the President directed them to adopt a formula. This was solely adopted, Madam Chair. This was solely adopted by the DPWH. And so, this particular of deliberate design of corruption mechanism certainly does not recite a fact to prove, to be able to state that there was institutionalization of this formula. Now, let's go to the others. Because clearly, it is a formula done solely by the Department of Public Works and Highway. Next, B. Let's go to B, page 20. Let us all go to this. Concentration of contracts, 100 billion to 15 billion favored contractors. Where is the statement here that these contractors were directed by the President to Public Works to be given? In fact, Madam Chair, the President himself was the one who exposed these 15 favored contractors, and thank God there is no favored contractor, these 15 in Cagayan de Oro 2nd District. That is why, Madam Chair, this is not a recital of fact to support the institutionalizing of this formula from the President. Next, geographical misallocation given to Bulacan, Oriental Mindoro, Tarlac. Is there a link that the President ordered that this be given to them? None whatsoever. This was all the function, implementation, and planning by the DPWH. So this geographic misallocation are statements which are irrelevant to the institutionalizing. That is the charge, institutionalization. So therefore, this will fall. There is no sufficiency here in the recital of facts. Then we go to D, betrayal, abandonment of the public good for private enrichment. Here, we can see here that once again, the systemic betrayal has no recital of fact that will show the President's involvement in this particular formula. And then, they go to the conclusion. My goodness, in the complaint, you don't have a conclusion. In the complaint, it already clear it's not a recital of fact because you state conclusion, corruption was systematic, not incidental. Conclusion of law not based on fact. That is on page 22. That is paragraph 92 to 93. And then we go to page 23. Now, legal conclusion. Now, these are now conclusions of law, which we will all disregard. Because when we go to a complaint, we go to the ultimate facts constituting the offense charge. So therefore here, it concludes, conclusion of law without any basis. It says, respondents Marcos institutionalization of the BBM parametric formula constitute betrayal. There is no link. Their conclusion jumps from the charge, paragraph 66, to paragraph 94 without any link of the President. And that is why, Madam Chair, clearly, the first ground of betrayal of public trust is not sufficient in substance. And this particular allegation should fall. Thank you, Madam Chair.
Thank you, Honorable Rodriguez. At this point, we recognize the Honorable Janice Digamo. We are still on the first offense, institutionalizing systemic corruption through the PBBM parametric formula of allocables. You may proceed.
Yes po. Good morning to everybody. I would like to express how I understand the procedure, lalong-lalo na doon sa unang grounds na binabanggit. At being a non-lawyer, I have to aralin po kung paano ko titignan yung sufficiency in substance. And sa akin pong pagre-research, lalong-lalo na ngayon na narinig ko si Congressman Rufus, pag ina-assess natin yung sufficiency in substance on the first allegation, natutunan ko that I have to look for the act, the document, and the violated duty. So dun sa first allegation, yung BBM formula is the act. But you will have to ask the question, who committed the act? Is it the President himself? Alam po natin, in-explain po ni Kong Rufus na hindi naman po. Ano yung document to support it? Nandun ba yung document to support the allegation? Dapat hinahanap natin yan pag nag-judge tayo according to the sufficiency of substance. At ang pangatlo po, yung violated duty. With the BBM formula and yung implementation has nothing to do with the office of the President or the President himself. Paano magiging si Presidente ang person to be blamed para dito sa sinasabi natin na BBM formula? You cannot see the hand of the President in all this accusation. Lalong-lalo na dito sa unang sinasabi nila ni BBM, the BBM formula. I think we have to go back to DPWH dahil sila yung nag-i-implement ng programa. Pwede kasi na ang intensyon ng Presidente for giving the budget is very good. Pero yung nag-i-implement ang nagiging problematic. So saan yung kamay ng Presidente doon? Yun yung hanapin natin dapat. So yan lang po, that's my peace of mind, Madam Chair. Thank you po.
That manifestation of the Honorable Digamo reminds the Chair to encourage the members to speak in a language where we will be understood by our beloved countrymen, no? This is actually the power of the sovereign people, and I hope that through this public hearing, we are able to communicate where this power truly rests, no? So we encourage the members as much as possible to speak in Filipino so the people will understand us. Thank you, Honorable Digamo. This is still on. All right. In response to Honorable Digamo,
Yes.
we
On
recognize
the
the
comments
Honorable...
made by the Representative Rodriguez and Representative Digamo.
All right.
As well as earlier, the Representative
The
Navas.
Honorable Ilago is recognized.
Yes. Madam Chair, tungkol doon sa first act ng betrayal of public trust, doon sa pagpapatupad, pag-implementa ng sistematiko na korupsyon sa pamamagitan ng baseline balanced managed parametric formula of allocables. Ang charge po doon sa complaint nakalagay na ang respondent, President Ferdinand Bongbong Romualdez Marcos Jr. betrayed public trust by institutionalizing a systemic scheme of corruption through the adoption and implementation of the so-called baseline balance managed parametric formula as the official allocation mechanism for flood control and other infrastructure projects, thereby converting the national infrastructure budget into a centralized apparatus for plunder. Kanina pa ho sinasabi na DBM naman ang nagsulat niyan, DPWH naman ang nagsulat niyan, ang author, DPWH naman ang nag-implement. No? Pero ang hindi po sinasabi dito, no, sa ilalim din ng ating konstitusyon, ng ating saligang batas, Section 17 of Article 7, the President shall have control of all the executive departments, bureaus, and offices. He shall ensure that the laws be faithfully executed. And corollary to this is the doctrine of qualified political agency, aka the alter ego doctrine, which the Supreme Court explained that the President's power of control is directly exercised by him over the members of the cabinet who, in turn, and by his authority, control the bureaus and other offices under their respective jurisdictions in the executive department. Ang bottom line, Madam Chair, tulad ng nabanggit din ng ating mga complainants doon sa nakasaad mismo sa complaint sa paragraph 67, page 18, na noong July 22, 2022, noong first month pa lang na nag-assume ng presidency si Pangulong Bongbong Marcos, ang DPWH nga ang nag-adopt nitong BBM parametric formula bilang official methodology for allocating the unprecedented 545.6 billion in flood control appropriations mula noong 2022 hanggang 2025 na budgetary cycle. Nandyan din ho, paragraph 92, page 22, yung alleged kickbacks na predictable at intended consequences ng institutional design choices mismo ng respondent sa pamamagitan ng BBM parametric formula. Paano, Madam Chair? Ang bottom line dito, yung mga written internal policies na adopted and implemented by the agency by virtue of the qualified political agency, siya po dapat yung lahat ng ito ay attributable mismo sa presidente. Unless meron talaga siya na express, no written, na nagsasabi na ito ay kanyang hindi inaaprobahan. O ito ay or merong disapproval mismo ng presidente. At yun yung hindi natin nakita. Bagkus, nakita pa natin na ito ay nagpatuloy at nag-cause ng malawakan, sistematiko na korupsyon na nagbigay daan doon sa malawakan na pagnanakaw sa pondo ng ating bayan. Kaya, Madam Chair, kami po ay naninindigan na merong personal na involvement, ito po ay may basbas ng Pangulo at hindi ito magiging posible kung hindi mismo pinayagan, sinusugan ng Pangulo mismo.
The manifestation of the Honorable Ilago is noted. Our
Madam
last
Chair.
speaker for the first offense, the Honorable Padiernos.
Madam Chair, and afterward.
Let us finish first with the manifestation of the Honorable Padiernos, and then we will be calling the Honorable Ko.
Thank you, Madam Chair. So, just a quick manifestation. Madam Chair, after carefully reviewing the complaint and with respect to the first allegation on the so-called PBBM parametric formula, this representation is in the position that the allegation is insufficient in substance. Una po, walang batas at walang jurisprudence na nagsasabing illegal ang paggamit ng isang budgeting or allocation formula. Pangalawa, wala ring ipinakitang dokumento na nagsasabi na personal na nilikha o inutos ito ng Pangulo. While the recital of facts could possibly constitute the offense charged, the allegations do not point that as to the formula, the same is attributable to the President. The allegation in paragraph 91 stating that, and I quote, the scope and scale of this corruption spanning multiple senators, cabinet secretaries, undersecretaries, district engineers, contractors, and intermediaries could not have operated without the institutional architecture created by the respondent is at most presumptive or speculative. Even if cabinet secretaries are alter egos of the President for purposes of executive control, the doctrine does not automatically convert every administrative issuance into a personal culpable act of the President. In this case, the complaint does not allege that the President directed, approved, ratified, or even knew of the questioned policy, much less that he acted in bad faith. Malinaw po to sa ating jurisprudence under Estrada versus Desierto and Gutierrez versus House Committee on Justice. Impeachment requires a personal overt act and culpability. the alter ego doctrine cannot supply what the complaint fails to plead. Dahil walang illegal act na na-plead personally against the President, this does not constitute an impeachable offense. Again, Madam Chair, I just want to reiterate, the recital of facts as mentioned for the first allegation could possibly constitute the offense charge or betrayal of public trust in this case. But we have to also consider, does that offense, is it personally attributable to the President himself? And this representation is in the position na in the negative po. So yun lang po, Madam Chair.
Thank you, Honorable Padiernos. Now let's hear the comment from Honorable Ko.
Thank you, Madam Chair. Madam Chair, just to reiterate the discussion of Representative Sara Elago, we talked about kanina yung doctrine of qualified political agency. Ito ay well-established in jurisprudence. Ang sinasabi lang naman po nito, yung acts of department secretaries, presumed yan na acts of the chief executive or the president, no, unless disapproved. At ang may burden ng showing kung may disapproval man or hindi, nasa challenger, no. So una po, nasa attachments po natin yung tinatawag na BBM parametric formula. This is a 16-page document which says, no, that this formula was used para i-prepare ang 2023 National Expenditure Program. At ano po yung act of the executive that validates yung use of this formula? No? It is the signing of the NEP. In fact, kung i-extend pa natin, no, meron pong, we could take judicial notice of the claim by now DPWH Secretary Vince Dizon that in the preparation for the 2027 NEP, they will not be using the BBM parametric formula anymore. That is an implied admission na even up to the 2026 NEP ay ginagamit pa rin po yung parametric formula na ito, which says that the priorities of leaders of the national government will be considered in approving infrastructure budgetary allocations, no, yung matatawag nating allocables. In fact, meron din po tayong attachments in the complaint which says, no, and tags NEP items. They are for OP, ES, SAP, indicating presidential involvement in implementing the formula for allocables. So ibig sabihin po, this presumption, no, may presumption na itong act ng secretary na doon po sa formula, clear po sa document na galing po to sa Office of the Secretary. So we assume na act po ito ng President. And then yung act of the President of signing the GAA 2023 onwards validates po yung use of the formula. Yun po ay alleged in the facts of the complaint that is recited. And so ito po yung pinopropound natin, no, na at the end of the day, may tag budget items and NEPs and allocables for OP, and thus, no, magsastand po yung argument. Thank you, Madam Chair.
Madam Chair.
Madam Chair.
Madam Chair.
The Honorable Rodriguez and then the Honorable Abante.
The doctrine and the presumption of qualified political agency was pronounced by the Supreme Court in the case of Planas versus Hill, Mondaño versus Helvosa. I cannot forget that first year law school. And in that case, precisely, it's a presumption. Because then it can be rebutted by evidence. Now, it would have been incumbent on the complainants that they will be able to strengthen this presumption by putting up a link of qualified political agency, alter egos of the President in terms of implementation of the public works to implement, he is the alter ego being a secretary. That is a presumption that everything is done correctly. Now, it would have been incumbent of the complainants to be able to show and strengthen this presumption by saying that this particular qualified agency was
in fact, directly, it's not anymore a presumption because they're alleging that it is direct. It is not anymore presumption because they are now charging that there is institutionalization. So therefore, the case of Planas versus Hill and Mundaño versus Silvosa, they can research that now because I just remembered it. First year law school. Now, therefore, they cannot hide now, the complainants cannot hide now under the cloak of that presumption because they are now filing a case against the President. And so therefore, everything in the face of the documents there should be a recital of facts. So the presumption cannot hold anymore because they are now filing the case. And they are now saying that this is not only a presumption, it is done and it is what is that the President is linked to the institution, which there is no recital of fact on that. Thank you, Madam Chair.
Thank you. Next is the Honorable Abante.
Yeah, Madam Chair, the explanation of Congressman Rufus is actually more than enough. No, pero I'd like to add to this. No? Ito naman tinatawag nating the doctrine of command responsibility, where we say that the act of the Secretary is the act of the President, and the act of the department heads is the act of the Secretary. Ano ha? Yan po'y general rule eh. General rule po yan. But there is always exception to a general rule. For example, sa akin po sa akin, alter ego is not immunity. But also not strict vicarious criminality. Unlawful acts are not acts of the state. And liability analysis remains individualized for wrongdoing. Kaya nga po iniimbisigahan pati ang Secretary Bonoan eh. Kaya nga po tinanggal Kaya nga po may kaso. Bakit pinabayaan ng ating Pangulo na kasuhan niya mga yan? Kung siya po ay talagang author ng lahat ng mga nangyayaring yan. Therefore, ito po itong number 1 na ito, the argument na binigay sa atin, with due respect to Congresswoman Sara, at na talagang mga close din sa akin to mga to. No? Pero the thing is this po, kinakailangan malaman po ng taong bayan na hindi po ito yung absolute rule. General rule po ito. At naniniwala po tayo na ang unlawful acts ng sino mang alter ego ng Pangulo, hindi po ito act ng Estado. Kaya nga po ito'y iniimbisigahan. Kaya nga po naniniwala ako na hindi po ito nauukol sa tinatawag nating sufficiency of substance. Thank you, Madam Chair.
Madam Chair. Madam Chair.
The Honorable Tino.
Thank you, Madam Chair. Maikling mga manifestation lang po. No? Una po, malinaw at direkta po ang recital at pakahulugan dun sa unang bahagi ng betrayal of public trust, institutionalization ng allocables at sistema ng corruption sa pamamagitan ng BBM parametric formula. Ano po ang akto? Malinaw na po kahit dun sa title mismo, high level ng dokumento na kasama po sa mga attachments at official na dokumento ng DPWH. High-level budget allocation formula, the baseline balanced managed parametric formula adopted in 2023 National Expenditure Program Preparation. No, yung National Expenditure Program, yun po, ang tawag nga po dyan, the President's Budget. No, so ito yung budget na nilalagdaan ng Pangulo at sinasubmit sa Kongreso at itong nagiging batayan ng General Appropriations Bill. So yun po yung malinaw na sinasaad dito na ibig sabihin ng institutionalization ng sistema ng korupsyon. At nais ko lang pong ipaalala na hindi lang naman po yung policy na yon ang batayan ng unang bahagi. Kasi sasabihin niya, policy lang naman yan. Anong masama dyan? No? Kaya nga po kasama rin po dito yung mga testimonya, sinight yung mga testimonya ng mga whistleblower, kasama si Yusek Bernardo at ilang mga kontraktor, at nandun din po sa complaint, sa attachments, yung mga records nun na nagsasabi na ito ang naging basis ng kickback, no, ng mga ghost projects, substandard projects, kickbacks, and commitments. So yun po ang buong recital, kaya sinasabing may betrayal of public trust ang Pangulo. Yun lang po ang gusto nating ilinaw dito.
Of course, we value the long-standing principle of law, no? As a matter of fact, that qualified political agency is considered as one of the landmark cases, and you will agree with me. However, the Honorable Padiernos made mention about one jurisprudence which provides there has to be personal, overt, culpable act to constitute an impeachable offense. I would just like to give this chance to the Honorable Ko if she wishes to comment to that as well.
Thank you, Madam Chair. To us, no, it is clear na yung act na po yun is signing of the budget. No? Passing the budget and then later on signing the budget. Na ginamit po doon yung BBM parametric formula to be able to distribute yung system of allocations.
We note the answer of the Honorable Ko. So
Madam
that
Chair, I just wanted to add on
Honorable Padiernos.
the alter ego doctrine. Madam Chair, the alter ego doctrine only creates a presumption in terms of administrative purposes. It does not establish personal culpability for impeachment. Kasi kung ganun lang din po, di lahat na lang po ng cabinet memo na in-issue, kung nagkamali in the future, sinabing mali, eh lahat na lang po yan pala impeachable offense. So it sets a bad precedent or precedent that, you know, if the president would be silent on matters like such as this, then automatic guilty na po siya. Parang ganun po yung dating. So yun lang po, Madam Chair.
Madam Chair,
Honorable Tino.
just reply to that. Yung sinaside po na jurisprudence with respect to delegated authority and so on, this is with regard to criminal liability. No? Pero ang pinag-uusapan po natin dito ay betrayal of public trust. Kaya nga, sabi nga kanina, acts that fall short of criminal acts. Kaya hindi po nag-a-apply yung binabanggit niya rito, no, dahil ang pinag-uusapan po natin ay acts that fall short of a crime, an actual crime. No? Yun lang po ang gusto nating ilinaw.
Thank you, Honorable Tino. And as our last speaker, last to comment on the first offense is the Honorable Digamo.
Thank you po, Madam Chair. Madam Chair, when the President affixed his signature, malamang po bilang Presidente, ang iniisip niya yun talagang this will do good. These projects, this fund will be translated into projects that will protect lives and properties. Inaasahan po ng Presidente na magiging maganda ang gagawin ng agency kung saan pinaglalaanan niya ng pondo. Bakit ko po ito nasabi na the allegation lack in substance? Because wag po nating kalimutan that during the SONA, the President himself called the attention of those hearing officials na sa paniniwala niya, nagkandasira-sira ang maganda niyang plano dahil sa maling pag-i-implement po. I hope everybody in Congress will remember that ni-remind ng Presidente. Kaya hindi ko po makita yung kamay niya dito dahil siya mismo nag-remind kung paano, anong ginawa niyo sa pinagkatiwala ko sa inyo. Thank you po.
This should be the last of the last.
Yes,
The
Madam
Honorable
Chair.
Elago.
Opo, we cannot and should not speak for the President. Kaya nga po nananawagan ng taong bayan na maipasa ito pagdating sa sufficiency in substance na para magkaroon na tayo ng hearing, mapatawag yung Pangulo mismo at marinig mismo natin mula sa Presidente yung kanya pong paliwanag kung bakit po nahayaan itong malawakan na korupsyon sa pamamagitan ng adoption at implementation ng BBM parametric formula at yung mismong paglagda niya sa ating pambansang budget. Okay, thank you.
We will be terminating our
Madam
deliberation
Chair,
on the
Madam
first
Chair.
offense. Of course, we recognize the efforts and contributions of the members for the valuable exchanges of opinions, including principles of law. That concludes our deliberation on the first offense. We will now move to the second offense. Second act of betrayal of public trust, abuse of discretionary power over unprogrammed appropriations. Now we elicit the opinion, position, comment from the members. The Honorable Adyong.
Thank you. Thank you very much, Madam Chair. Bismillahirrahmanirrahim. Madam Chair, I understand that the direction of the committee is to compartmentalize the issues or the complaints under the Maza et al. Complaint, Madam Chair. But allow me first to at least touch on the first issue that was discussed earlier. And I understand, Madam Chair, that many of our members here, many of the members here have already spoken and expressed their manifestation regarding the first offense or the first complaint that was discussed. So my approach, Madam Chair, on these complaints, on how I understand it, is based on not necessarily on a legal perspective, because many of us here in the committee, I understand, are non-lawyers. So our approach here is, first of all, we based our observation on what is guaranteed in what are laid down in the Constitution that would constitute impeachable offenses. Number two, based on how the public would perceive these proceedings. Kasi ordinaryo pong tao nakikinig po sa atin. Minsan po hindi maintindihan kung ano po yung mga pinag-uusapan dito, and we cannot fault them because these terms, recital of facts, admissibility of evidences, these are legal terminologies that we can often see and hear them during a regular court proceedings. So my position here, Madam Chair, in the way I approach this is based on coming from an ordinary, average-minded Filipino. Madam Chair, the allegations stated in the complaint, to me, do not constitute betrayal of public trust. In an alleged violation of public trust, the alleged acts must be short of criminal. Tama po yung sinabi po ng aking kaibigan, Congressman Tino. However, the allegations as to receiving supposed kickbacks imputes a commission of a crime. That is a substantial defect, to my view, in the allegation presented. Because number one, the chosen charge is wholly and fatally inconsistent with the alleged act. There's a claim of direct personal involvement, but the same is merely conclusory and unsupported by sworn statements, documentary evidence, or the personal knowledge of the complainant. Meaning to say, Madam Chair, if there's a complaint in the impeachment proceedings such as this, while we are actually appreciating the sufficiency of substance, there has to be at the very least a link between the alleged crime committed and the person that is being accused directly ordering these crimes. This is borne, Madam Chair, out by the superfluity of general accusations, assumptions, and inferences, and the lack of identifying dates, specific transactions, responsible officers, or any overt act personally attributable directly to the President. Wala sa complaint mismo, Madam Chair, ang mga personal at direktang aksyon ng Presidente na magiging basihan para sa nirereklamong charge. There is not even a direct allegation to explain how these alleged kickbacks reached the President. Madam Chair, hindi po dapat gamitin ang impeachment proceedings bilang fishing expedition at hindi maaaring gamitin para sa akin, as stated earlier by my colleagues, the mere essence of a principle of command responsibility lamang o ang policy decision bilang basihan ng impeachable offense without necessarily, again, linking the President to personally ordering his subordinates to craft a policy that would be considered a direct culpable of the Constitution, constituting therefore an impeachable offense. In fact, Madam Chair, the Supreme Court has stated that the betrayal of public trust must refer to direct and personal acts by the accused. Number one, basic, Madam Chair, is to establish bad faith. The complaint relies heavily on singular, unverified, and unsworn testimonies, Madam Chair. The alleged testimonies do not meet on any material point that would establish direct, personal, and intentional participation of the President. In the Supreme Court decision, Madam Chair, cited by the complainants, which held that special provision from the GAA was unconstitutional for being a rider and for impliedly repealing the Universal Health Care Act, the court also denied to pass on the liability on the Department of Finance. In fact, Madam Chair, individual justices in their decisions stated that the Department of Finance followed the challenged provision in good faith. So there's no culpability, even if you look at the ruling of the Supreme Court. That the finding of good faith defeats, Madam Chair, the accusation of betrayal of public trust because the same requires attendant grave and serious bad faith. There is no factual chain of culpability kung pagtatagpi-tagpiin po natin ang mga ebidensya na sworn, competent, at admissible. Hindi may papakita na mayroong partisipasyon po ang Presidente. Yun po ang basic na tanong ng ating taong bayan. To allow such fragmented and legally infirm allegations to substantiate an impeachment complaint would dangerously lower the constitutional threshold for impeachment. It would weaken the impeachment process, as explained to us extensively by the able chairperson yesterday. To allow barefaced and unsupported claims which do not directly implicate the respondent as basis for impeachment would erode due process, weaken institutional safeguards, and expose impeachment to abuse as a tool for political harassment and, I'm afraid, Madam Chair, destabilization. For all of these reasons cited above, I find that the allegations, Madam Chair, with due respect to my friends, do not constitute a betrayal of public trust. Marami pong salamat sa Madam Chair. Magandang umaga po sa ating lahat.
Thank you, Honorable Adjong. Now we recognize the Honorable Lordan Suwan.
Prohibited by law. In fact, they are referenced in Section 35, Book 6 of the Administrative Code. And so, presidential approval of the release of these funds does not equate to discretionary indulgence. It is actually a requirement of law. And on another point, the complaint mentions extensively about the case of Pimentel versus House of Representatives. This is regarding the PhilHealth funds. Now, their reliance, the complaint's reliance on that case, I think, is misplaced. We must differentiate, because that case addressed the constitutionality of a specific funding mechanism in the General Appropriations Act. It did not find any instance of presidential bad faith, corrupt intent, or or personal enrichment, nor did it characterize the release of unprogrammed appropriations as betrayal of public trust. Let's remember that judicial invalidation of a budgetary provision cannot be retroactively transformed into an impeachable offense. A ruling against a budgetary provision is not a ruling against the President. Now, the complaint also mentions extensively about the increases in unprogrammed appropriations amounts. And it seems that the complaint would make it appear that there is a grand criminal design, and it was the President who is behind all of this. But in my opinion, there is a much simpler explanation in the increase of unprogrammed appropriations. It might very well be a response to post-pandemic recovery. This is a simpler explanation of this increase. And also revenue contingencies or even disaster-related responses. And regarding alleged irregularities in the execution of projects, this cannot be directly attributed to the President, but can be attributed to guilty or erring implementing agencies and even contractors. So, for me, as to the alleged second act of betrayal of public trust, the complaint falls short, or it appears that there is an insufficiency in substance.
Thank you, Honorable Suwan. Next in line is the Honorable Amben Amante.
Thank you, Madam Chair. The complaint raises unprogrammed appropriation and alleged kickbacks, yet it fails to establish any direct link to the President. Walang claim that he received money or property. Walang claim that he personally benefited. Walang illegal transaction showing personal participation. Walang allegation that he ordered, joined, or colluded in any kickback scheme. References to unprogrammed appropriation do not lead ultimate facts tying the President to corruption. At law, unprogrammed appropriation are valid under the Administrative Code and were affirmed by the Supreme Court in Bellica versus Executive Secretary. In short, mere pagkakadismaya with how funds were allocated cannot substitute for evidence of personal wrongdoing by the President. Madam Chair, mere policy disagreements, pagkakadismaya with budget outcomes, or speculative allegation cannot substitute for direct presidential wrongdoing. Without ultimate facts supported by clear and convincing evidence, the complaints fall short of the constitutional threshold for impeachment. The question we must ask are simple. Ano ba talaga ang ginawa ng Presidente? Where is the evidence? Where is the law? Until these questions are answered with proof, the charge cannot stand. Thank you, Madam Chair.
Thank you, Congressman Amben. For the guidance of everyone, all the members, we are still on the second offense. That is the unprogrammed appropriations. We have a list here, and next in line is, if he is ready, Honorable Emeng Pascual. You want to be called later.
Here, who are in the list? So that I can include, if I propose to include my name.
Yes. Next to Honorable Emeng is Honorable Alan T. And then Honorable Garbin likewise raised his hand. Honorable Laila de Lima, and then Honorable Rodriguez.
Madam Chair, can you include my name too?
Yes, Honorable Abante. So for the guidance of everyone, Honorable T, Honorable Garbin, Honorable de Lima, Honorable Rodriguez, Honorable Abante. For the information of the Vice Chair Dumogan. For the information of the committee, Honorable Alan T is using a slide, 2 slides to aid him in his expressing his manifestation. Honorable T, you may proceed.
Thank you, Madam Chairperson. The rules of procedure in impeachment proceedings requires that an impeachment complaint be sufficient in substance before it may proceed. Sufficiency in substance demands a recital of ultimate facts and a determination of these facts, if admitted, constitute a valid ground for impeachment under the Constitution. Despite its length and extensive recitation of budgetary figures, testimonial excerpts, and policy outcomes, the second impeachment complaint fails to meet this constitutional threshold. Volume, however, is not a substitute for ultimate facts. The complaint relies on inference rather than personal knowledge, characterizes discretionary policy mechanisms as criminal conduct, and imputes the alleged acts of third parties to the President without pleading specific overt acts personally attributable to him. Allegations are based on hearsay and lack personal knowledge. Section 3, Rule 2 of the House Rules of Procedure in Impeachment Proceedings requires that a verified complaint be based either on complainant's personal knowledge or based on authentic records. A review of the complaint shows that its central accusations rest on the testimonies, interviews, and statement of third parties. None of the complainants allege that they personally witnessed the President ordered, approved, or participated in any alleged kickback scheme. The complaint repeatedly cites Senate testimony, media reports, and investigative narratives to support the conclusion that the President orchestrated a system of corruption. These sources merely recount what other individuals claims to have observed or inferred. Allegations derived from hearsay, no matter how frequently repeated, do not constitute ultimate facts and cannot support a finding of sufficiency in substance. Failure to allege any act personally attributable to the President. Notably, the complaint does not allege a single specific act supposedly committed by the President, despite sweeping claims of institutionalized plunder and betrayal of public trust. Impeachment is not a doctrine of vicarious liability. The President cannot be impeached merely because officials within the executive branch exercise discretion, nor because Congress later disagreed with how such discretion was exercised. Assertions that the President sits as to the top of the bureaucracy or that policies bear his political branding do not establish culpability. What the Constitution requires is a clear nexus between the President's own acts and the alleged offenses, a nexus that is entirely absent from the complaint, as borrowed from the term of Congresswoman De Lima.
We are waiting for your slides.
Yes. Policy disagreements are not impeachable offenses. A substantial portion of the complaint attacks the design and implementation of budgetary mechanism, including the so-called PBBM parametric formula, the use of unprogrammed appropriations, and fiscal prioritization decisions. These matters fall squarely within the budgetary process. The executive proposes with the submission of the National Expenditures Program, Congress legislation with the passage of the General Appropriations Act, and budgetary execution by the executive. As stated in the General Appropriations Act itself, unprogrammed appropriations are expressly authorized by Congress and may be availed of only upon the occurrence of statutory conditions and the required certification, underscoring that their use is conditional and not an exercise of unfettered executive discretion. Unprogrammed appropriations are not discretionary funds in the sense alleged by the complaint. The complaint itself cited special provisions on unprogrammed appropriations under the General Appropriations Act. As can be seen from the slides on the unprogrammed appropriations, under special provision paragraph 1, A, B, and C, there are conditions that must be met before you can avail of the unprogrammed appropriations. 1, paragraph A, there must be an excess revenue, new revenue collection, or those arising from new tax or non-tax sources,
or approve loans for foreign-assisted projects, and only after certification of fund availability by the Bureau of Treasury. As can be seen also, Your Honor,
Point of
that-
order, Madam Chair.
Yes.
There's a point of order from the Honorable Ko.
We just like like to clarify that the budget being I'm sorry, point of information rather than point of order.
If that is a point of information, then we should allow him to finish first.
Okay. Okay, thank you, Madam Chair.
All right. The Honorable T, please proceed.
Thank you, Madam Chairperson. Note that unprogrammed appropriations are standby and conditional appropriations that may be only used only upon the actual realizations of paragraph A, B, and C, and certification of fund availability by the Bureau of Treasury. Until these statutory conditions are met, the executive has no discretionary authority to release funds and is further limited by the purposes expressly approved by Congress under the unprogrammed appropriations section of the GAA. Can you show the next slide, please? As to the purposes. As you can see, there are purposes that these funds that can only be utilized for the following purposes as stated in the General Appropriation Act. The executive may not release funds absent the statutory triggers, nor may it divert funds to purposes not authorized by law. Accordingly, the use of unprogrammed appropriations after compliance with statutory conditions and certification requirements cannot be equated with arbitrariness, illegality, or impeachable conduct. To do so would conflate lawful budget execution with criminal intent and collapse the distinction between policy implementation and constitutional violations. Disagreement with fiscal allocation priorities constitute a political or policy dispute, not a culpable violation of the Constitution. To accept the complainant's theory would be transformed impeachment to a mechanism for penalizing governance actions, thereby collapsing the separation of powers and undermining the constitutional design. There is failure also to state a cause of action for betrayal of public trust. The complaint invokes betrayal of public trust as catch-all ground for a collection of administrative grievances and political accusations. However, jurisprudence requires that this ground involved acts so grave and outrageous that they strike at the very core of public office. The complaint fails to allege any document signed by the President ordering unlawful disbursement, any transaction in which he personally received funds, or any commission on audit findings identifying him as a participant in illegal activity. General references to COA observations, Senate inquiries, and media reports do not amount to ultimate facts. The complaint relies on ongoing investigation and Senate inquiries to supply evidentiary support for several allegations, demonstrating that it's not evidentiary complete at the time of filing. Impeachment is not a discovery mechanism. A complaint must be sufficient in substance at the time of filing, not after hearings, subpoenas, or political inquiry. In sum, the second impeachment complaint is long on rhetoric but short on ultimate facts. It relies on hearsays, conflates policy disagreement with impeachable offenses, and imputes the alleged acts of others to the President without pleading direct participation, and are contradicted by the official records such as the General Appropriations Act. To allow such complaint to proceed would erode the constitutional safeguards governing impeachment and reduce it to a tool of political contestation. For failing to meet the rigorous standards of sufficiency in substance, the complaint should be dismissed. Thank you, Madam Chairperson.
Honorable T, would you like to reiterate your argument in showing the purposes in the slide?
Well, the purposes of showing the slides on unprogrammed appropriation shows that there are conditions to be met before the unprogrammed operation can be availed. So there are conditions to be met as provided for under paragraph 1A, paragraph 1B, and paragraph 1C.
All right.
Likewise, Madam Chair, if I may proceed.
Yes, please continue.
Also, as to the increase on unprogrammed appropriation, the complaint itself in page 9, paragraph 28, and if I may quote, on December 11, 2023, this is in reference to the GAA General Appropriation Act 2024, the Bicameral Conference Committee, referring to Congress, submitted a report that drastically altered the President's original proposal, meaning the increase in the unprogrammed appropriation from the proposed 281.9 billion to a staggering 731.4 billion, an increase of 449.5 billion was through the act of Congress. Likewise, in the very same complaint, to fund this explosion, as I quote, the committee, referring to the Bicameral Conference Committee, inserted a special provision 1D, authorizing the use of fund balances of government-owned and controlled corporation. Meaning, Madam Chairperson, it's not the President who increased the allocation of the unprogrammed appropriations. It is the act of Congress by the Bicameral Conference Committee that increases the budget allocation in the unprogrammed appropriations. Thank you, Madam Chair.
Thank you, Honorable T. Your quite lengthy manifestation is duly noted. Now we recognize the Honorable Garbin. There's a list, Honorable Chua. You will be after the Honorable Abante.
Thank you, Madam Chair. Let me proceed with my manifestation on ground number 2. The expansion and use of the unprogrammed appropriations as a shadow budget. The core allegation of the complainant is that the UA, or the unprogrammed appropriation, grew dramatically. Releases supposedly required presidential approval, and therefore, the President personally enabled the corruption. Why is it not sufficient in substance? First, Madam Chair, as correctly put up by Congressman T, the UA is a statutory budget mechanism enacted by Congress. The UA exists because Congress places it in the General Appropriation Act. The growth in the UA by itself is not unconstitutional. The complainant or the complaint does not plead which constitutional limit was violated merely because UA amounts increase. Number 2, no pleaded facts identify any UA-specific release that was illegal. The complaint cites aggregate figures and percentages, but does not identify. First, the specific UA item release, the condition precedent for the release, how those conditions were absent, and the issuance of the SARO or the NCA that prove its illegality. Madam Chair, even assuming the Supreme Court in the case of Pimentel versus House of Representatives found parts of the 2024 budget mechanism unconstitutional, that ruling does not establish an impeachable offense by the President. In the Supreme Court, dispositive portion ruled that the presidential certification of its urgency as not unconstitutional. And even if it were for the sake of argument, Madam Chair, such act in itself does not amount to an impeachable offense. It is just merely a democratic mechanism of checks and balance. The case addresses the special provisions, specifically paragraph 1D and its DOF implementation. It does not supply the project-level facts, procurement irregularities, the kickback transactions, or any willful bad faith. The complaint still asks the committee to jump from unprogrammed appropriations figures to corruption conclusions without the required linkage. On that basis, it remains, Madam Chair, that this allegation is insufficient in substance. Unconstitutionality of a provision is not by itself betrayal of public trust. Betrayal requires pleaded ultimate facts showing grave misconduct attributable to the President. The complaint uses unprogrammed appropriations, expansions as an insinuation, but it does not show willful bad faith, corrupt purpose, or direct presidential participation, nor does the SC ruling fill those gaps. Madam Chair, thank you.
Thank you, Honorable Garbin. Next in line is the Honorable De Lima.
Thank you, Madam Chair. Before I present again my own analysis of the second ground, I wish to state these observations. Well, one or two of the previous speakers again dwelled on the entirety of the complaint, and that includes the Honorable Representative Zia Alonto. And I cannot also help observing that about a couple of the previous speakers are actually dealing with the defenses, the possible defenses on the part of the respondent. Yung pagkakasabi po, with due respect to the Honorable Congresswoman Degamo, that the President must have been motivated by the desire to address the public good. That is a defense. Another one is on the part of what was stated by the Honorable Representative Suwan, that the increase can very well be, may be explained by the fact that this was during the pandemic period. Again, that is a matter of defense. Kaya nga po, paulit-ulit ko pong sinasabi sa lahat na analysis ko po, nang tinitingnan lang po natin dito is the sufficiency in substance. And then, just to also address the point of the Honorable Congressman Ting, he pointed to paragraph 28. On December 11, 2023, the Bicameral Conference Committee submitted a report that drastically altered the President's original proposal. So his contention is that it's not the act of the President, but the act of Congress through the Bicameral Committee. Pero hindi ho ba meron allegation sa complaint? And I think this is pages 40 to 41. Paragraph 40 to 41 and paragraph 50 to 51. Ang natatandaan ko pong nakasabi dyan, during the Bicameral Conference Committee deliberations in 2024, PBBM instructed DBM Secretary Amena Pangandaman to insert 100 billion worth of projects during the BICAM. Another allegation, related allegation, PBBM produced a list of projects worth 100 billion for insertion. This list was given to executive and legislative officials involved in the BICAM. So nobody can really say that the President's hand is clean with respect to those insertions, additional amounts included in the GAA as deliberated upon by the BICAM. So again, allegation. Hindi ko po sinasabi, totoo yan. And then, nakikita ko rin po sa discussion under ground 2, page 25 and page 26, or even part of 27. The complaint actually made a causal link to corruption. Meron po sila mga diniscuss dito. Several circumstances, which include the allegation that the top UA-funded contractors are now under criminal investigation. Kasi sila po yung mga supposedly reveal ng Pangulo, pero sila yung mga top UA-funded contractors. And these 4 contractors, yung Sunwest, Silver Wolves Construction Corporation, High Tone Construction, Newington Builders, received a combined 18.44 billion in UA-funded contracts,
funds released only
Madam Chairman.
because respondent
Madam Chairman.
personally approved the special budget authorizing
What
the
is the
disbursement.
pleasure of the Honorable SDML
With
Defensor?
due respect to the Honorable De Lima, may I raise a point of order?
You're recognized, SDML.
I respect the position of the Honorable De Lima, but we must also remember that every impeachment complaint, every impeachment hearing, regardless of who the respondent is, it is a political process. It is political in nature. And let's allow the members to speak what they have to say. We will not interrupt any member. We will not interrupt the Honorable De Lima. Let them manifest what they want to say, even the endorsers themselves. Let them speak. Surely we will finish this. But since this is a political process, let's allow them to say what they have to say and vote on it later on. That's all, Madam Chair.
We extended liberality to all the members in the same way that we are extending liberality to the Honorable De Lima. I think that's fair enough.
Thank you, Madam Chair. I don't think I'm in any way violating that rule because I'm not interrupting
You're not,
anybody
ma'am.
here.
You're not violating any rule. I'm
Yes.
just saying that let the members speak and let them say what they have to
Thank
say.
you. Thank you for that.
The manifestation of SDML Defensor is duly noted as well.
So ang sinasabi ko na naman po dito, naniniwala ako na meron talagang mga allegation, factual allegations that would constitute the ground for impeachable or would constitute impeachable offense. Nasabi ko nga po kanina, per the rules, dun lang tayo dapat nakatuon. Yung mga defenses, let the respondent himself raise those defenses in the proper time. That is sa answer o kaya sa rejoinder, kung gusto pa rin mag-rejoinder, kung merong reply ang complainant. So, yung iba po kasi mga naririnig ko sa mga sinasabi for the previous speakers, defenses na po sila. Why can't we not focus our attention to the specific allegations? Later, at the end of the, pag natapos na po natin yung third ground, I can point out to those specific allegations. Ayaw ko lang po kasi mag-touch on the entirety of the complaint. But at this point, I want to say na yung factual allegations para sa akin, dun sa tatlong complaints, ay sapat. So, tungkol naman po dito sa second ground, may I now again present my analysis. Ang sabi po, PBBM abused release of 213.8 billion of unprogrammed appropriations. Factual allegations. Although, sinimulan muna po ng parang isang treatise on the legal nature of UA or unprogrammed appropriations. So may discussion muna tungkol sa kung ano ang mga at saka kung ano ang mga limitasyon ng UA. Of course, these are not allegations of specific facts, pero hindi ibig sabihin wala ng factual allegations under this ground. It may look like to be a legal memorandum yung pagkakadiscuss sa second ground, pero sa tingin ko po, there are sufficient factual allegations that appear to establish a nexus with the ground for impeachment. Corruption, which is betrayal of public trust. Remember, isang general ground lang po ang rini-raise dito sa impeachment complaint. The second, the Maza et al. Complaint. And that is betrayal of public trust manifested in three specific grounds. 3 grounds. Pero, betrayal of public trust kasi is all-encompassing. Pwede nating sabihin na lahat ng iba na mga grounds, whether it's culpable violation of the Constitution, treason, bribery, graft, and corruption, ay kung tutuusin po, kung titingnan natin, these are all constitutive of betrayal of public trust. Kaya nga po, naiintindihan ko kung bakit yung complaint ay only alleges one general ground. So again, ano pa po yung mga factual allegations? SC declared unconstitutional the transfer of 89.9 billion PhilHealth funds as grave abuse of discretion. That is a sufficient allegation. Another, Secretary Recto admitted identification of PhilHealth Fund use for UA. Sufficient allegation. Another allegation, diversion of PhilHealth funds to UA used for flood control projects was the mechanism for kickbacks. Constitutes a raid of the nation's health fund by PBBM. Ito po, this is a conclusion. Another allegation, top UA-funded contractors are now under criminal investigation. Sufficient allegation. Nakasama sa discussion doon sa causal link to corruption, which was laid down on the text of the impeachment complaint. Another, PBBM authorized release of 213.8 billion of UA for infra. 111 billion was for FCP selected in accordance with leadership priority under parametric formula. Sufficient allegation po ito. The selection criteria used, though, included the parametric formula, which is a conclusion actually instead of a factual allegation. Katulad din po yung sinabi ko with respect to ground number 1. There may be statements of conclusions or conclusions of facts, but it does not change the fact, the evident fact, that there are factual allegations na merong nag-establish ng nexus. Another, amount of UA quadrupled from amount of unprogrammed appropriations quadrupled from 250 billion in 2022 to 807 billion in 2023. Sufficient allegation. Another one, PBBM signed off on 9 SARO worth 213.8 billion. Sufficient allegation. Next, PBBM used unprogrammed appropriation to circumvent congressional oversight. This is, of course, a conclusion. Parang legal treatise na naman po yung discussion dito on UA as insertions. Next, PBBM approved special budget for UA projects. Sufficient allegation. PBBM authorized 100 billion in FCPs for political patronage. This is a conclusion. So overall, a liberal treatment of this ground would favor a finding of sufficiency in substance, despite the plethora of conclusive allegations as opposed to factual allegations. Having these conclusions do not destroy the fact that there are indeed factual allegations, which when hypothetically admitted, can establish a nexus to any ground, especially betrayal of public trust. Again, hindi pa po mga defenses of the possible defenses of respondent ang pinag-uusapan natin dito, kundi purely on the sufficiency of the allegations. Thank you.
Madam Chair.
We allow the manifestations of all the members of the committee, including all possible arguments, that is to guide all of us or the members as we vote this afternoon on the sufficiency in substance of both the De Jesus complaint and the Maza et al. Complaint, notwithstanding the significance of the observation of the other member on the manifestation. In our proceedings, we are actually encouraging them to give a better understanding of what we need to determine as we end the deliberation this afternoon.
Madam Chair. Madam Chair.
Is this in connection with the manifestation of the Honorable Dilemma? Because
Yeah.
we have a list, Honorable Adjong,
Yeah, just a very short manifestation.
in relation to
yeah,
her
yes,
manifestation.
just a comment.
The Honorable Adjong is recognized.
Just a brief manifestation, Madam Chair. Madam Chair, I do completely understand and the observation and perhaps what the Honorable Congresswoman Laila de Lima would like to recommend for this committee to approach this current deliberation and current discussion that we're having right now. In particular, the assessment on how we value the sufficiency of substance of the allegations presented before us today. I do respect her views. In fact, Madam Chair, I do not even want to argue, perhaps, on the merits of what Congresswoman Laila de Lima laid out before this committee. She is known to be a legal luminary. We do value all her points. In fact, Madam Chair, the committee has been very liberal in trying to allow the former Secretary of Justice, former Senator, and our colleague to emphasize clearly what should have been the legal framework on how we approach the issue at hand, which is to assess, again, the sufficiency of substance of this matter. But then again, I would like to just point out, Madam Chair, that most of us here came out with our own manifestation and our position and observation, not necessarily to defend the respondent, Madam Chair. Because I believe that in this case, in particular, the President has all the legal resources. Should this proceed to another level, is more capable of defending himself. The individual observation and manifestation, Madam Chair, of many of our colleagues here are not defending per se the President, but this is also guided by the rulings of the Supreme Court, guided by the premise by which the Constitution laid out on how we approach impeachment proceedings. Number one, in my humble opinion, Madam Chair, first basic requirement that I would like to look into the allegation is if such an allegation established that there is bad faith in even trying to say that there is indeed an offense committed which constitute impeachable offense. The betrayal of public trust, Madam Chair, meron pong nakalay down doon kung ano yung mga ano, but ang para sa akin po, requirement is if there's really a bad faith. In this particular second allegation, kung may bad faith po dyan, ang nakita ko, Madam Chair, is that number one, the case of the Supreme Court over the unprogrammed appropriation is still pending. So we do not actually have a concrete response from the Supreme Court. That's number one. Number two is the initial ruling of the Supreme Court actually removes culpability on the DOH because the bad faith that was the bad faith, which probably would be the one to cite culpability on the part of the DOH, is absent according to the Supreme Court. There's no culpable violations or criminal violations for that matter on the ruling of the Supreme Court. So again, my humble opinion, Madam Chair, and again, I thank you for allowing me to say this, is the members who came out with their individual observations. Ang sabi nga po ng ating Senior Deputy Majority Leader, this is a political process. Allow our members to share their own opinions. We may not like what we hear from our members. We think that some of the observation assessment of our individual members might not even reach the standard of how we discuss legal matters in the impeachment proceeding, but at the very least, allow them to express their own views without labeling it as something defensive to favor the respondent, in this particular case, the President. We are guided by the rulings of the courts. We are guided also by the premise by which the Constitution has laid down on how we proceed with impeachment proceedings, Madam Chair. Maraming salamat po and thank you very much po sa opportunity.
Let us all be reminded that we are the representatives of the sovereign people here, and that is why the Chair has been very liberal about accommodating all the manifestations and arguments which are being raised and presented by the members of the committee. Nevertheless, moving forward, we recognize the Honorable Rodriguez.
Thank you very much, Madam Chair. The second act of betrayal is found on page 23. The charge: President Marcos betrayed public trust by, very important word, abusing, because betrayal of public trust, abuse. To solely, next issue, solely authorize the release of unprogrammed appropriations, channeling 213 billion in standby funds, and so forth and so on. So, abuse, and then solely. Now, let's go now to the next page. The legal framework that they provided already provides the ammunition why the president cannot be responsible. The legal framework states that precisely Section 35 of the Administrative Code of 1987 and the special provision number 1 of the 2024. They say establish an ambiguous is not big ambiguous because it's not ambiguous legal reality. The reality, according to them, is that the president personally controls the release of unprogrammed funds. Of course, being the chief executive, all the funds should go, especially under the law on unprogrammed funds. The law provides that the president will be the one issuing it. So already clear that the president is empowered by law, two provisions of law, Administrative Code and the General Appropriations Law. And then, 99, expenditures from this lump sum appropriation must be made in accordance with the special budget. You see, it's not solely the president. A special budget to be approved by the president because it comes first from the department, it goes to the DBM studies it, and then recommends to the president. He is not the sole. It's not out of nowhere, he will now release program funds. So, he, in fact, would support the fact that this particular ground has no sufficiency. Now, let's go to the judicial confirmation of abuse. Citing the case of Pimentel versus the House of Representatives, Special Provision 1D of the 2024 GAA, they say that this is a confirmation of abuse. I disagree. The Supreme Court struck down PD Presidential Provision number 1D. Why? Because the doctrine of operative facts, as early as 1971, second year, College of Law, 1977. The case of Serrano de Agbayani versus PNB already establishes the doctrine of operative facts. What is that? All the laws are valid and all acts of the executive or whatever official is valid until the law is declared unconstitutional. This case of Serrano de Agbayani versus PNB was followed by a litany of cases on operative facts, which are Belhica versus Ochoa Jr. and Bandadas versus Ochoa Jr. Now, Madam Chair, the operative fact means that everything, Secretary Recto has the authority because we have the provision of section of the special provision. We have a provision in our GAA that authorizes that excess funds of all government-controlled corporations may be remitted to the national government. Although he was wrong. They were wrong, but the law acknowledges that they were valid when they were transferred. In fact, the decision says that they are not responsible. Why? Because of the doctrine of operative fact. So therefore, Madam Chair, this entire charge falls under the doctrine of operative facts. Recto was right. Recto was doing what was right at the time. It was not yet unconstitutional. The President was right in having this release because that is the doctrine of operative fact. So I'd like the complainants to read. Serrano de Agbayani versus PNB, 1971 case, 55 years ago. And is still now being done by all the decisions, including Pimentel III. So therefore, Madam Chair, how can we blame the President on this particular release coming from unprogrammed funds when they were legal with the special provisions, being legal at the time, declared to be unconstitutional later on? So, Madam Chair, then let's go back to the others so that we can have the causal connection. Because all of this will fall already, but I'd like to just emphasize for the record. The causal link to corruption, here, this is now the vague statement that would make the signing of the President, the act of signing into law our GAA, which is deliberated by the House and the Senate, the signing will become an illegal act and subject to impeachment. This is what is stated in 104. By certifying the 2024 budget as urgent and signing it into law with special provision 1D, he is now therefore directly enabled and constitutional siphoning At that time, it cannot be unconstitutional kasi wala pa nga. At the time that this was transferred, there was no declaration of unconstitutionality. Again, the doctrine of operative facts. So, then, after this, we go now to paragraph B, circumvention of congressional oversight. How can there be a circumvention when these program funds released are not anymore under the law subject back? Otherwise, every release of the President, the complainants would want the Congress to be the one to decide through oversight. How can we do that? There's just so many items in the program funds. And that's why the Chief Executive is given that power by law to be able to release. There is no, as far as we are concerned, oversight function that we can reverse the President. The old President can veto, and that is the time we can reverse him. But after that is signed, it is already law. So there is also nothing in paragraph B, circumvention of congressional oversight. Then we have again legal conclusions. You do not put in a complaint your legal conclusions. The judge will decide on that. Civil cases, there can be no legal conclusion because that is subject. That is why you are recital of facts, so that the judge, in this case, the Committee on Justice, will decide whether there is a basis to consider to continue with the trial or not. So, Madam Chair, clearly, the doctrine of operative facts absolves everybody in relation to unprogrammed funds. In relation to PD presidential of the special provision number 1 of the 2024. Doctrine of operative facts. As early as 1971, Serrano de Agbayani versus PNB. Moratorium case, the moratorium of non-payment of utang to the government on housing. So, all the collection were valid until it was declared unconstitutional. So therefore, Madam Chair, it is clear that there is no basis in fact to be able to proceed even hearing this case because everybody is absolved already. That is the law. And the law is read into all complaints. Thank you, Madam Chair.
What distinguishes a dean of College of Law from a lawyer? A lawyer knows the law, but the dean knows the evolution of the law.
No, the difference, Madam Chair, from a lawyer is that how to become a dean. A lawyer who does not know how to practice law, he becomes a law professor. And a lawyer who loses his cases and does not know how to teach, he becomes the dean of the College of Law, San Sebastian College of Law.
Thank you, Honorable
Chair.
Rodriguez.
Madam Chair, I beg to respectfully disagree with
Okay,
Congressman
let's give
Rufus.
chance to break the monotony of this very
I disagree also,
heated
Madam Chair.
discussion. Let's give
36
chance
years
to
po ako.
another Dean, Dean Jokno, to react to the statement of Dean Rodriguez.
36 years po ako kung Rufus nag-practice bago po ako naupo.
Exception
bilang
of
dean.
Chel Jokno, of course.
Madam Chair, I
Thank
will
you,
be
Madam
signing the
Chair.
impeachment complaint of Congressman Jokno against Congressman Rufus Rodriguez.
All right, so let's move forward. We recognize the Honorable Vice Chair Dumogan.
Thank you, Madam Chair. Well, I do not like to repeat what already been narrated by the previous speakers, but let me go to the point why it appears in the allegations that there are a statement of facts. But to me, I feel that it's my function not to stop there but to continue because of our own rule that the complaint must be verified and based on personal knowledge of the complainants. It's not because there are allegations of facts, then we stop there and determine that it is sufficient in substance. No. We have to determine if they have the personal knowledge on this one. That's our role requires. That's why, looking at the allegations on the second ground for betrayal of public trust, with abuse of discretionary power over unprogrammed appropriations, paragraphs 117 to 180. Again, I do not see an evidence that will link the president. It's not defending the president, but to me, it's part of my function to find out if the complainant has the personal knowledge. If you look at them, based on newspaper clippings, we already said that in the case of Desierto, Supreme Court said that newspaper clippings are more or less hearsay. Second-hand information. And then, of course, the alleged confession of Saldico. That's not the confession of the complainant, or there's no allegation that the complainant was present when this was made. So, I hope my colleagues will understand why I still proceed even despite the fact that there are factual allegations already stated, but trying to find out whether or not the complainants have personal knowledge as required by our own rules. And let me point out that even in the complaint itself, it is stated that, look, a lot of certain individuals and contractors are facing charges already. Investigations are going on. And this had been done by the act of the President of denouncing these anomalies. How can we now reconcile that and come out to a conclusion that he was involved in this one without any piece of evidence that will link the President to the commission of an impeachable offense? So I respectfully submit that on ground number 2, it is not sufficient in substance. Thank you.
Madam
Thank you.
Chair,
Thank
just
you,
a brief...
Vice Chair Dumoga.
Madam Chair.
In reaction to Vice Chair Dumoga,
Yes, Madam Chair.
please make this quick, honorable dilemma.
Thank you.
Thank you.
Thank you, Madam Chair. Only on the point of the verification based on personal knowledge. Remember that in our rules, it says based on personal knowledge or based on authentic records, and we can extend it further based on publicly available documents. Kasi po kung ganyan, lahat na complaint ay talagang siguruduhin na personal knowledge o i-require na based on personal knowledge, wala na po sigurong magpa-file ng impeachment complaint against anybody. Kasi itong mga ganitong mga issues, these are public issues. Nasa public discourse yan. So naririnig yan sa radyo, nababasa yan sa newspapers, information online, etc. So that's not strictly personal knowledge, but it's publicly available information as long as based on authentic records or publicly available information or documents. We cannot just say, we cannot just be insisting all the time na dapat ay personal knowledge. Mahirap po yan. Wala na pong uusad na impeachment complaint kung purely based on personal knowledge ang kailangan i-allege. Take a look at all the impeachment complaints filed now. Ito pong dalawa against the President, and then yung dalawa so far against the Vice President. May iba doon, personal knowledge. But pangkalahatan, hindi po personal knowledge ang mga yon. Kasi mahirap na i-require nga na purely based on personal knowledge.
Itong mga, including itong mga naka-allege po dito sa complaint. Of course, we based it on reports. We based it on testimony. Yung later po sa number 3, nandun yung mga supposed na mga claims ni Saldico, and then yung supposed na mga claims din ni former Yusek Bernardo, affidavit, testimony before the Senate. Those are supporting proof. Pero hindi sinasabi na totoo yung mga sinasabi ng mga nag-claim ng mga ganong facts. Marami po, lalo na sa ground number 3. Thank you.
Without disputing the manifestation of the Honorable De Lima, the Chair wishes to state for the record that the verification requires personal knowledge and/or authentic records.
Yes.
It's or.
Moving forward, Vice Chair Dumogan.
Madam Chair, it's or.
You have already mentioned, Madam Chair, that
All right.
it must be based on personal knowledge or authentic records. That's what our rules require. And as I was pointing out, I will not stop only on the establishment of statement of facts, but we have to find out relation to the personal knowledge or authentic records, which unfortunately there is none here. That's my point.
With the indulgence of the Honorable De Lima and the Vice Chair Dumogan, we have a list. So we will be moving to the next speaker, the Honorable Benny Abante.
Thank you, Mr. Chair, Madam Chair. I truly appreciate the statement of Congresswoman De Lima on what she said. I listened very intently on that. No, pero I'm just wondering what abuse of discretionary power when it is not the president that actually approved the unprogrammed funds. He signed it because he has the discretionary power to do it. But I would not even think that he forced the congressman to approve such unprogrammed funds. Anyway, the title alleges abuses or abuse. But the complaint must plead facts, not only personal knowledge, but plead facts showing abuse, not merely invoke discretion. For example, the charge accuses the respondent of abuse of discretionary power over unprogrammed appropriations. But a charge is not made sufficient by a label. It must plead a recital of facts constituting the impeachable offense. I am not talking as a lawyer, but I am talking also as a logical man. You see? According to Section 25, Article 6 of the 1987 Constitution, and I quote, budget execution and disbursement operate within constitutional constraints, including limits on transfers, augmentation, and requirements that discretionary funds be disbursed only for public purposes, supported by vouchers, and subject to guidelines prescribed by law. I would think that the president knows all about this, including his economic managers. And because the Constitution regulates how appropriations may be used, therefore, a charge of abuse must identify, at minimum, what legal constraint was breached and what act violated it. Here, binasa ko po yung lahat ng binanggit dito on the abuse of discretionary power, wala po ako nakita. No pleaded factual anchors. For example, the complaint does not allege the acts or omissions constituting the charge. On the face of the charge of abuse, Madam Chair, it fails to allege the key factual particulars that would constitute abuse, such as what unprogrammed appropriations was released or obligated, the amount and date, the project, the purpose and implementing entity, the recipient or beneficiary, and the specific constitutional statutory limitation violated. Without these particulars, sa pagkaintindi ko, the accusations remains a conclusion, not a recital of facts constituting the offense charge, as required by the Gutierrez case. That's the reason why I still maintain insufficiency in substance as far as the second act of betrayal of public trust is concerned. Thank you, Madam Chair. Salamat.
Thank you, Honorable
Madam
Abante.
Chair.
Next in line
Madam
is...
Chair.
What is the pleasure of the Honorable Ko?
Madam Chair, just to quickly respond on the manifestation of Representative Abante.
All right, you're recognized.
Thank you, Madam Chair. Madam Chair, in regards to a specific recital of fact on the alleged gross abuse of discretion, I would like to point to paragraph 116. It is to summarize it. And to clarify po, yung pinopoint po natin na abuse of discretionary powers is not yung approval of UA, but yung release of unprogrammed appropriations. After po ng pag-sign ng budget, kailangan pa po ng mga special budgetary requests para po mailabas yung UA. And so, in the complaint, meron din pong paglista ng UA released versus approved. So, mas malaki po yung in-approve versus na nirelease, but nonetheless, tinotal po natin yan, ang na-release. So, and to recall, according to the Administrative Code and to the special provisions of 2023 GAA and 2024 GAA, kailangan po yan ng approval ng Presidente. 213.8 billion ang nirelease. And among that 213.8 billion, that's 111 billion for flood control projects. No, so yun po yung pinupunto natin na abuse of discretionary power. Hindi po yung approval that went through the Congress, pero even after ng approval, may kailangan pang special budgetary requests to be approved by the President. Yun po yung gross abuse of discretionary power. And siguro, just briefly po, on the mention of the doctrine of operative fact, we are aware na may discussion nun, but to note, under Pimentel versus House of Representatives, the court found that hindi po i-apply yung doctrine of operative fact. And dinidirect ang PhilHealth na ibalik sa PhilHealth yung pondo. And hindi rin po wala rin pong basis to say na maa-absolve of liability yung mga officials because of such application, which hindi naman po ginawa in the first place. Thank you, Madam Chair.
Madam Chair, let me clarify.
I anticipated this.
Yeah.
Honorable Rodriguez.
The doctrine says that everything that is done during the time when the law or executive order is valid is under the operative fact doctrine is valid. And so, valid si Recto. Valid ang executive department because there is a law that provides that excess funds of government-owned and controlled corporation. And PhilHealth is clearly a government-owned and controlled corporation. So they are valid. And so therefore, you cannot question their act. It is now declared unconstitutional. Now, it is also the right of the Supreme Court to have it returned. But there is no responsibility of Recto. In that case, if we extend that, the President, in releasing all of those that has been approved by law, has no accountability. If you are citing Pimentel as a judicial justification of your complaint, it cannot be. Because the doctrine of operative fact follows. And that is why we have what we have. That's why the case against, the personal case against Recto will not prosper because of the doctrine of operative fact. Thank you.
Madam Chair.
Okay, so we will move to the next speaker, the Honorable Chua.
Maraming salamat po, Madam Chair. Madam Chair, nandito pa lamang po tayo sa second act of betrayal of public trust, abuse of discretionary power over unprogrammed appropriation. At kanina nga po, nabanggit na ito pong charge ay matatagpuan po sa page 23, paragraph 96. Sabi po dito, Respondent President Ferdinand Bongbong Marcos betrayed public trust by abusing his constitutional and statutory discretion to solely authorize the release of unprogrammed appropriation. Pero nakaligay po dito at maliwanag na ito po ay kanyang constitutional at statutory discretion. The word discretion itself ay maliwanag, hindi po ito mandatory. Ibig sabihin, hindi po niya ito kailangan gawin. Ito po ay nasa kanya pong discretion. At maliwanag po dito, paano po ang sinasabi po dito sa ating rules. Sabi dito, the requirement of substance is met if there is a recital of facts constituting the offense charge. Asan po ang offense dito kung ito po ay kanyang constitutional duty? Pangalawa, Madam Chair, sinasabi po ng ating esteemed colleague ang kanila pong basis dahil po sa ang binanggit po nilang decision ng Korte Suprema ay yung pong decision patungkol po sa PhilHealth. Pero kung titignan po ninyo dito, ito po ay sinasabi po dito matatagpuan sa page 24, paragraph 102, the court ruled that the executive branch act of diverting 89.9 billion from PhilHealth to fund this unprogrammed item constituted grave abuse of discretion. Pero ito po ay patungkol sa PhilHealth Fund, hindi po doon sa kabuang unappropriated unprogrammed appropriations. In fact, ito pong issue sa unprogrammed appropriation ay hindi pa po ito nadidesisyonan ng Korte Suprema. Wala pa pong sinasabi ang Korte Suprema na ito'y illegal. So paano po natin sasabihin na ito ay isang offense against the President? Na ang Presidente, basahin lamang po natin to, wala na po tayo makikitang offense. Pangalawa po, sinasabi po nila dito, to finance the systematic corruption scheme detailed in the first act of betrayal of public trust, so forth and so on, ito po ay purely speculative. Wala pong basis dito po na nakalagay sa second act of betrayal. Paano po ito nagamit to finance the systematic corruption? Kaya, Madam Chair, sa akin pong paniniwala, by mere determination of substance, dito pa lamang po, makikita po natin wala. Otherwise, kung sasabihin po natin na ito pong unprogrammed appropriation ay naabuso po ng Presidente at sasabihin natin na hindi po applicable dito yung sinasabi pong doctrine of operative fact, edi sana po nakasuhan na rin po yung dating Presidente nung dineklara ng Korte na yung DAP ay illegal and unconstitutional. At kagaya po na nabanggit kahapon, ito pong unprogrammed appropriation, lahat po ng administrasyon as far back as 1989, pagkatapos po ng EDSA Revolution, lahat ng administrasyon, lahat ang gobyerno, taon-taon, since 1989 up to the present, lahat po ang administrasyon ay may unprogrammed appropriation. So short of saying, lahat ang naging presidente ay dapat nakasuhan din po natin. At hindi lang po ang presidente, lahat ang local chief executive, lahat ang governor, lahat ang mayor, meron din po silang lump sum appropriation. Kaya po, Madam Chair, ako po naniniwala, by mere perusal of the second act or the second ground for impeachment complaint, wala po, insufficient po ang substance. Yun lang po.
Thank you, Honorable Chua. Next in line is the Honorable Deputy Speaker Janet Garin.
Thank you very much, Madam Chair. Thank you, distinguished colleagues. Madam Chair, let me dwell into the issue on betrayal of public trust. Kasi sang-ayon sa nakikita natin, ang nakasulat base dito sa complaint is that this is basically all about unprogrammed appropriations. May I request our colleagues to endorse this impeachment complaint? When we talk about unprogrammed appropriations, saan na mga ahensya ito dumadaan and who are the final determinants of the approval and listing of such, including prioritization?
Deputy Speaker Garin wishes to raise a question.
Sa General Appropriations Act, partikular ng 2023 at 2024 na binabanggit dito sa complaint, ang sinasabi po doon ay ang paggamit ng unprogrammed appropriations ay magiging alinsunod sa Section 35, Chapter 5, Book 6 ng Administrative Code. So may explicit reference po sa special provision ng unprogrammed appropriations dito sa provision na ito. At ang sinasabi po ron na expenditures from lump sum appropriations, so ibig sabihin, sa GAA mismo, sinasabi na ang unprogrammed appropriations ay isang tipo ng lump sum appropriation na covered ng provision na ito. At ang sabi ay expenditures from lump sum appropriations authorized for any purpose or for any department, office, or agency in any annual General Appropriations Act shall be made in accordance with a special budget to be approved by the President. So yun po yung proseso na tinatakda. So kung meron pong
Madam Chair, if
purpose
I
sa
may,
unprogrammed appropriations, kailangan
Please
gumawa.
let the Honorable Tino finish his
Kailangan
answer.
gumawa ang kinauukulang ahensya na covered nung purpose na yon, authorized, ay na gumawa ng special budget at ito ay isusumiti sa Presidente para sa kanyang approval. At sa approval lamang ng Presidente, maaaring gastusin ang unprogrammed appropriations. So, Presidente po ang may sole and exclusive na kapangyarihan at discretion kung ano ang maaari at hindi maaaring paggamitan ng unprogrammed appropriations.
Madam Chair,
The
let me
Honorable
go
D.S.
back
Garin.
to the answers of the Honorable Tino. Balikan po natin. While it is true that you cited a provision in the General Appropriations Act, at ang pagkakaintindi mo ay it's the sole prerogative of the President, let us look at the actual process. That's why I was trying to interrupt earlier, and apologies for that. Balikan natin. Unang-una, saan ba nanggagaling yung paglista ng unprogrammed appropriations? If the good sponsor can directly answer the specific agency or the specific agencies.
Honorable Tino.
Yung step 1.
Depende po sa purposes na nakasaad sa unprogrammed appropriations. Kung gusto nyo po, pwede nating tignan
Yeah.
ang
With due
mga
courtesy to
special
the Honorable
provisions.
Tino, if I may,
At
balik
kung-
tayo dun sa
tutuloy ko lang po.
proseso.
At kung ang purpose na tinutukoy katulad sa 2024 ay yung tinatawag na CPAG, which covers infrastructure programs.
Yeah. Madam Chair,
dadaan po,
with
ang
due courtesy,
DPWH
please
po ang
allow Honorable
magpe-prepare.
Tino to finish the answer.
DPWH po, ang secretary ng DPWH ang magpe-prepare ng special budget.
Okay. Madam Chair, if I may, with due
Honorable
courtesy
Green.
to my colleague, can we answer direct to the point? Kasi gusto kong i-establish yung proseso so that I can be guided on whether there is it is sufficient in substance or not. Let's go back to the process. Ang tanungan natin, where does it emanate? And if I get it correctly from your answer, it emanates from the department. Is that right, Madam Chair?
Honorable Tino.
That is correct.
Okay. So, ibig sabihin, itong listahan ng unprogrammed appropriations, lahat na ito ay nanggagaling sa kanya-kanyang departamento. Is that correct, Madam Chair?
Po.
After the department would pencil that in, saan po siya napupunta, Madam Chair?
Honorable Tino.
Madam Chair, dadaan ito sa DBM.
Okay. And in the process of going to the Department of Budget and Management, who defends that proposed list of unprogrammed appropriations, Madam Chair?
Honorable Tino.
Mas maganda, Madam Chair, na tanungin ang mga kinauukulan dito, pero sasagot ako batay sa aking nalalaman at
Point of order,
ang
Madam
proseso
Chair.
na ito.
Sorry,
There's a point of order.
Madam Chair.
SDML Lawrence Defensor is recognized.
Let's reinstate our original rule that the members will have their own manifestations. And if ever we find this to be sufficient in substance, then we can exchange interrogation. But at this point, let's go back to our earlier rule yesterday that we can say whatever we had to say and let our individual conscience assess whether the allegations in the recital of facts constitutes an impeachable offense. So we don't have to argue back and forth.
We allow the sponsors or the endorsers to answer so long as they want. And if the speakers or the members are not willing to consider the answers, then the speakers are advised to do their manifestation by way of a speech or straight manifestation instead of raising question. Would you like to answer?
Yes, Madam Speaker, and in consideration of the manifestation of the Honorable Senior Deputy Majority Leader, isang sagot na lang po. Basta malinaw po sa proseso na itinatakda ng batas na manggagaling sa departamento ang proposal for as long as authorized under the purposes of the unprogrammed appropriations for that year. Tapos, dadaan sa DBM. Pero ultimately, at ito po ang pinaka-importante, ang autorisasyon ng paggamit sa unprogrammed appropriations ay sa presidente. No? Ang ibig din sabihin nito, meron din siyang kapangyarihan, kung mayroon siyang kapangyarihang mag-authorize, meron din siyang kapangyarihang hindi mag-authorize. At yun po ang isang batayan na sinasabi natin kung bakit inabuso niya ang kapangyarihang ito. Kaya po, betrayal of public trust.
Madam Chair.
Honorable Garin.
Yeah. Thank you very much, distinguished colleague, for that response. The reason why I asked that is that I wanted to be clarified because based on the complaint, it stated and it appears, and especially during the initial answers of our distinguished sponsor, tila ang naipapalabas na ang presidente ang may diskresyon or may kapangyarihan at pumili kung ano ang mapopondohan. But contrary to what I am hearing now, based on the direct answers of our distinguished colleague, the unprogrammed appropriation starts with a proposal from each department, duly vetted by the DBM, defended by the proponent, and these are the cabinet secretaries or their alter egos who are the undersecretaries, and once approved, these are included in the NEP, the National Expenditure Program. After that, it is forwarded to Congress and Senate. Kung meron mang mga dinagdag, binawas at pinalitan, this is being done because of the budget deliberations that happens between the legislative bodies and the executive offices, meaning each department. Moving forward, Madam Chair, and just to manifest, sa pagkakaintindi ko in the budget process, once the General Appropriations Act is approved, there is a list of unprogrammed appropriations, meaning it will be funded once may pondo, may savings, or may loan. And as to my understanding, it is presumed that the Department of Budget and Management follows the chronology of prioritization set forth in the GAA as approved by Congress and Senate. After which, again, when there are funds that are available, this is being carved out from the approved GAA based on the prioritizations again. After which, it goes to the President for approval, which, on my understanding, Mr. Chair, is done by the technical finance people. While I agree that meddling in the unprogrammed appropriations, if indeed it is true, is wrong, I do not see the connection between the liability of the President and this allegation simply because, example, the mention of the statement, the unprogrammed appropriations mechanism was designed specifically to fund the discretionary priorities of leaders' allocations. This is a vague accusation that has been left unproven, and how will the President know, handling a very big country, know the individual request if indeed it is true? Next, Madam Chair, it can set a precedence for future actions because, again, the inaction of the President to approve or to sign the request of the DBM that was carved out from the prioritization as stated in the General Appropriations Act might be misconstrued as he is being remiss of his duty because that is expected to have passed through the proper channels, considering that, again, prioritization and listing emanated from the end user, the department, duly vetted by several technical people, culminating before Congress and Senate and going back to the DBM for implementation. In other words, Madam Chair, much as I wanted to ask questions because I really wanted to be clarified, but with due courtesy to the manifestation of our good Senior Deputy Majority Leader, let me just state it clearly. Unang-una, sino ang nag-request? Ito yung iba-ibang mga departamento. Sino ang nagtatanong kung ito ba ay kailangan o hindi? The technical people of the Department of Budget and Management who are career people. Hindi nga ito yung executive, hindi ito yung secretaries. After that, it goes to the cabinet. And the cabinet endorses that to the President. And then it becomes the National Expenditure Program. Dumadaan ng Kongreso, dumadaan ng Senado, nagkakaroon ng sagutan ang legislatura at eksekutiba. After the approval of that GAA, kung saan nakasaad doon yung 1, 2, 3, 4, 5, and my understanding, Madam Chair, is the chronology is followed. So kung ang Presidente ngayon ay isa-isa yang titingnan that will set for a precedence by us giving the signal that the President is supposed to be the technical financial determinant of all of these factors. In other words, Madam Chair, mali yung sumobra masyado yung unprogrammed appropriations, if indeed that is true. However, I find it unfair to blame it on the President because we, as members of Congress, should also have taken a proactive stand in policing, in asking the cabinet secretaries, and this is precisely the reason, Madam Chair, I'm just looking out of the balcony. May I request my distinguished colleagues that we should activate the oversight committees in Congress so that whatever requests on a program appropriations that the cabinet secretaries are putting forward should also be vetted, especially the impact and the prioritization. Kasi yung pasunod-sunod na numero nun galing sa proponent, nasa budget, at ina-approve, andun na lang sa pinakahuli what the President usually does, is synonymous to a ministerial duty, allowing the technical people and the executive people on the ground to apply what has been approved by many aspects in our government. Thank you, Madam Chair.
Madam Speaker, Madam Chair. Madam Chair.
Thank you, Honorable Diaz-Garin. The Honorable Tino is recognized.
Kailangan ko lang pong tumugon kasi mukhang meron pong basic na misunderstanding ang kagalang-galang na Deputy Speaker Garin sa aligasyon dito sa ikalawang bahagi. No? Kasi parang ang intindi niya na ang abuso ng diskresyon ng Pangulo ay naganap during budget preparation, yung paghahanda ng NEP. Pero hindi po. Ang tinutukoy po natin dito ay abuso ng diskresyon ng Pangulo during budget execution, sa paggastos na po ng budget, hindi na po sa preparasyon. No? Kaya hindi po natin kine-question dito to raise, to also engage with the point earlier raised by several other representatives. Hindi po natin kine-question dito yung Act of Congress na nag-approve ng unprogrammed appropriations. Ang kine-question po natin yung pagpapatupad ng Pangulo. At ang dinidiin po natin, ayon sa batas, sole and exclusive ang kapangyarihan ng Pangulo dito. Bakit po ganun ang batas? Bakit binibigay sa Pangulo ang sole discretion to authorize the use of unprogrammed appropriations dahil lump sum po siya. Inaprubahan ng Kongreso ang unprogrammed appropriations na meron lamang general purposes pero walang line item na magtutukoy kung ano-anong mga proyekto ang nasa ilalim ng mga purposes nito. Lump sum po yun. No? Kaya nga po, tinakda talaga sa admin code na kailangan, kung gagastusin ng unprogrammed fund na lump sum, kailangan may direct authorization ng Pangulo. Dahil sa mata ng batas, siya na ang final check and balance dito. May responsibilidad siya na tiyakin na yung paggagamitan ng unprogrammed appropriations ay matino at totoong proyekto na magsisilbi talaga sa interest ng mamamayan at hindi lamang ghost, hindi lamang kung ano-anong proyekto na pagkikitaan lamang. At yun po ang sinasabi nating abuso ng discretion. Kaya nga, inugnay po natin ang pagpahintulot niya, ang failure niya to exercise proper discretion, kaya naipakita na rin na yung marami sa mga tumanggap ng proyekto na pinondohan ng unprogrammed appropriations ay ngayon may kaso sa ombudsman, mga contractors na katulad ng SunWest at Silver Wolves, among others. Yun po. So, Madam Chair, mukhang hindi yata naiintindihan ng ilan kung ano yung aligasyon dito sa
With all
complaint.
due respect
Madam
to
Chair.
Diaz-Garin and the Honorable Tino, we have provided both parties ample opportunity to ventilate their respective arguments and views. We will be terminating your discussions on this point, and we will be moving to the next speaker.
Madam Chair, can I have a last recap to review?
If I allow you for the last recap, Diaz-Garin, will Honorable Tino request again for another recap?
It depends. Madam Chair.
With the indulgence of both parties, we are terminating the discussion of your contrary views on this point.
Madam Chair, just a very quick 1-minute manifestation. Just for the record.
The Deputy Speaker is recognized.
Yeah. Madam Chair, just to manifest, hindi po totoong hindi ko naiintindihan ang budget process. Yes, it's a lump sum allocation, but there is an accompanying list enumerating the prioritization and the numbering of the programs. Ang listahan ng mga proyekto, because this has to be corrected, because people listening might think that it's another pork barrel. While it's considered a lump sum, kaakibat doon ang listahan ng mga proyekto na dapat pondohan. And what I am saying, Madam Chair, we cannot set a precedence that will put our government in a jeopardy dahil wala nang gagalaw kung sinasabi natin ang presidente ang dapat maghimay tumingin at tingnan ang technical at pinansyal na aspeto ng bawat proyekto. In summary, Madam Chair, yes, the authorization is mandated by law to come from the President, but that signature comes only at a point where the Cabinet, the DBM, Senate, and Congress has finished all the vetting process, and he approves based on the knowledge that it is needed, it is the priority, and he does that commensurate to the chronological listing submitted and attached to the General Appropriations Act. Thank you very much, Madam Chair.
That is the last. Would you
Madam
like
Chair.
to make your last recap?
Madam Chair,
In the interest
I will
of
not
due process.
reply to that, Madam Chair.
So there ends your discussion. Let's move to the next speaker. The Honorable Eming Pascual is recognized.
Thank you, Madam Speaker. Madam Speaker, ito hindi lang para sa atin, sa committee ito o sa kongresong ito, para na din sa maintindihan ng buong Pilipinas, ng sambayan ng Pilipinong nanonood sa atin ngayon. Tama po, na tinatalakay at pinag-aaralan nating mabuti ang mga issues sa impeachment complaint na ito. Pero dapat din po na ang ating pag-aaral ay dahil sa ebidensya at hindi dapat batay sa spekulasyon o opinyon lamang ng kahit na sinong tao. Matapos ko pong basahin at pag-aralan ang mga nakasaad, ang mga basihan ng impeachment complaint ay naalaman ko na sa kabuuan ay wala pong matibay na ebidensya dito. Puro hearsay at sariling opinyon lamang. Ayun ang naging basihan ng impeachment complaint sa sinasabing partisipasyon sa kickback ng ating Pangulo ay wala po kung makitang matibay na ebidensya. Puro hearsay lang po ang opinyon at reklamo dito. Sa sinasabing issue sa katiwalian ng Pangulo ukol sa hindi pagbito sa unprogrammed appropriation na nakalista sa national budget ay wala din po kung makitang sapat na ebidensya na magpapatunay na may nasabing katiwalian dito. Tama po ang sinabi kanina ni Congressman Joel Chua. Meron pong constitutional discretion ang lahat ng executive. Kung dapat siya magbito o hindi. Sino-sino po ba ang mga executive? Yan po ang Pangulo ng Pilipinas, ang gobernador, ang mayor, maging ang kapitan ng barangay. Ako bilang dating mayor sa aming lungsod, hindi po ako nagbibito. Depende po sa amin. Tama din na sinabi ni Congressman Joel Chua kanina, magbuhat noong 1989, pagkatapos ng EDSA Revolution, naging tradisyon na po ito, ang unprogrammed appropriations na ito. Eh di dapat po, marami ng presidenteng natanggal. Kanina, ang sabi ni Congressman Egay Erice, kung pipigilan ng committee ito ang pag-usad ng investigasyon, ano ang magiging imahe ng Kamara? Mayroon daw po tayong pinagtatakpan dito. Para sa akin, hindi po. Hindi tayo papangit ang imahe sa Pilipinas sapagkat ang committee ito dapat po tumingin tayo sa tibay ng ebidensya. Hindi sa tibay ng video o ng mga news clippings. Halimbawa po, para sa kaalaman ng mga tao sa Pilipinas, ang dating Congressman Saldico, ginamit na ebidensya para sa impeachment complaint. Nasaan siya? Yung video clippings niya na hindi naman niya sinumpaan dito, hindi yung authenticate na siya talaga yung nagsasalita na yon. Paano po natin tatanggapin dito? Para sa akin, yung second offense po ng unprogrammed appropriations, napakalinaw po para sa akin, insufficient in substance. Thank you, Madam Chair.
Thank you, Honorable Pascual. Last speaker for the second offense is the Honorable Brian Po.
Thank you, Madam Chair, and to also recap everything. I want to point out para sa mga kasama natin dito at para sa mga viewers natin that though controversial, I think it's understood that it has not been, or unprogrammed funds has not been deemed as illegal, unlike other budgetary measures in the past, like the DAP or the PDAF, which the Supreme Court ruled on, and it changed the way we did our budgetary process. So now, it no longer exists in the way we implement our budget, but this shows an evolution of the budgetary process. As of the moment, ang unprogrammed funds po has not been deemed as illegal, which is why the wording of this complaint specifies the authorization of the release of funds. However, authorizing the release of funds in and of itself is not abuse, and it is not abusive. And it is very difficult to prove that there was a bad intention in the authorization of the release of the funds. The abuse or the alleged abuse that we are discovering in the hearings that we are conducting is in the implementation, Madam Chair. And the President himself is not directly involved in the bidding process for these projects. And therefore, it's hard to say that the President is involved in that abuse or the alleged abuse. Another point in this ground is the point on circumventing congressional oversight. Madam Chair, unprogrammed funds do not circumvent congressional oversight. Yes, it is our way of giving the executive branch leeway in case there are unforeseen expenses in the future. However, it is not without guidelines that come first from Congress, as which was said by our Deputy Speaker earlier. In the 2025 unprogrammed funds, there were certain items that were signaled as okay by Congress for unprogrammed funds to be used. Government infrastructure, GOCCs, foreign assisted projects, risk management, etc. In the 2026 unprogrammed funds, the priority shifted because of the complaints of our kababayans. It shifted because of the concerns raised by the minority and other groups. So the shift ended up focusing more on foreign assisted projects, risk management, and AFP modernization with some provisions vetoed. The point here being, Madam Chair, and what I want to highlight is it went through a congressional process. It was approved by Congress, and it was reacted to in the succeeding budget process, meaning there is still a level of congressional oversight which takes place over unprogrammed funds, which is why for me, while it is more specific in its approach towards the unprogrammed funds, specifying the authorization, it is very hard for me to see a grave abuse of power and a betrayal of public trust based solely on the authorization of a release, based on the fact that the abuse that we have seen takes place in implementation, and there is a level of congressional oversight, Madam Chair.
Thank you, Honorable Po. This is in
Yes, Madam
response
Chair,
to the manifestation of the Honorable Po.
This is just a short manifestation
Honorable
to follow
Ilago.
through on the earlier point of information made by Representative Reneco.
All right. Before we proceed to our third and last offense, Honorable Ilago.
Yes, Madam Chair. Earlier on, we'd like to clarify the version of the General Appropriations Act. The unprogrammed appropriations part presented by the Representative T. No? Kung anong taon po ito? Tama po ba ito ay 2025, GA?
Correct. It's 2025.
Yes. Okay. We just like to inform Madam Chair that what was cited in the verified impeachment complaint against President Marcos Jr. was the 2024 JAA and not the 2025 JAA.
You mean it's 2024 only?
Yes. That's all, Madam Chair.
Honorable T.
The GAA 2024 also states the very same provisions in the GAA 24, except with the additional paragraph 1D in GAA 2024. But as to the paragraph 1A, 1B, and 1C, they are the same with GAA 2025. for clarity only, Madam Chair.
Honorable Ilago.
To state for the record on the matter of bad faith. As an element po dun sa betrayal of public trust as alleged by the complainants. Paragraph 114, pages 26 to 27, respondent personally signed off on a system that number 1, bypassed rigorous planning and technical vetting. Number 2, funneled billions to favored contractors. Number 3, resulted in 421 confirmed ghost projects and thousands of substandard structures. And number 4, left Filipino communities more vulnerable to flooding than before.
All right. So that concludes our deliberation on the second offense. We will now proceed to the third offense. Please allow the chair to read. Third act of betrayal of public trust. Direct personal involvement in budgetary insertions and kickback schemes. We are now eliciting the opinions and comments of the members of the Justice Committee.
Madam Chair, may I
The
be
Honorable Dean
recognized?
Jokno.
The third charge in the Maza et al. Complaint, Madam Chair, alleges that President Marcos betrayed the public trust by personally and directly ordering the insertion of at least 100 billion pesos worth of anomalous flood control projects and other infrastructure projects into the 2025 GAA, and also receiving kickbacks from these projects. Ibig po sabihin ng involved po dito ang mismong direktang pagkakasangkot kay Pangulong Marcos. To support this charge, the complaint alleges that the quote-unquote Saldico confession confirmed the President's personal and direct involvement. At this stage, Madam Chair, we are not yet looking into the truth of these allegations, but rather under the threshold requirement, we simply assume that these allegations are true for the purpose of determining whether the complaint is sufficient in substance. And I respectfully submit that given that standard, that these allegations are assumed to be true, the complaint, insofar as the third ground is concerned, does satisfy the threshold standard of sufficiency in substance. Ako po ay naniniwala na dapat humarap si Saldico dito po sa atin para malaman na ma-cross-examine ng mga members ng komite at mahusgahan siya, hindi lang ng mga mambabatas, kundi ng sambayan ng Pilipino. Kung talagang totoo ang sinasabi niya o may laman ang sinasabi niya. I respectfully submit, Madam Chair, that we should proceed to the next stage of the proceedings, at least insofar as this ground is concerned. Thank you.
Thank you, Honorable Jokno. Any other member who wishes to make a manifestation on the third offense?
Madam Chair,
The Honorable De Lima.
I support the view, I concur with the view of the Honorable Representative Chel Jokno about the third.
Honorable De Lima, kindly speak closer to the microphone.
Thank you. I support and concur with the view of the Honorable Representative Chel Jokno with respect to the third ground. Again, it's direct personal involvement in budgetary insertions and kickbacks schemes. Sa tingin ko po, itong third ground ang pinakamalakas. Because if take a look at the allegations of the complaint, lalo na yung tungkol sa mga claims o mga sinasabi through a video ng dating representative and chair of the Appropriations Committee. It would seem, if hypothetically admitted, meron talagang impeachable offense. Napakarami ng mga sinasabi niya. Ganon din yung pag-cite ng mga testimony ni Yusek Bernardo. And yung tungkol naman po sa Cabral files. Katulad po ng sinabi ni Representative Jokno, hindi po natin sinasabi na totoo na o paniniwalaan o credible yung mga sinabi na yon ng dating Representative Zaldico sa video. At dapat talaga bumalik siya dito at sabihin niya under oath yung mga claims niya. Napakarami po. Starting from paragraphs 40 up to 51. Imagine. Ko alleged that the instructions to accommodate the insertions came directly from President Marcos Jr. himself. Ko stated that DBM Secretary Amena Mina Pangandaman called him during bicameral conference committee deliberations in 2024 and relayed, quote, katatapos lang ng meeting nila ni Pangulo at may instructions na mag-insert o magpasok ng 100 billion worth of projects. In subsequent video statements released on November 15 and 16 and November 24,
Madam Chair, can we ask
26,
Congressman De Lima
2025.
to please adjust her microphone?
Kindly speak closer to the microphone, Honorable De Lima.
Salamat po. First, sa paragraph 41, may na-skip ako kanina. Former Undersecretary Bersamin, Executive Secretary Lucas Bersamin's nephew, confirmed that the President directed according to Ko. Then Speaker Romualdez told Ko, when he immediately called the former Speaker after Bersamin's confirmation, what the President wants, he gets. Days later, Pangandaman and then Undersecretary Bersamin met with Ko and Romualdez at Aguada Building in Malacanang, etc. Meron sinasabi dito about a brown leather bag. In subsequent video statements released on November 15 and 16 and November 24 and 26, Ko provided additional details. He displayed photographs of suitcases allegedly containing cash delivered to then Speaker Romualdez and President Marcos. He denied receiving money himself, although hindi ho ata nakapaniwala, stating all the insertions went to the President and to Romualdez and that he merely facilitated deliveries. He described the delivery system. DPWH District Engineer Henry Alcantara's people would transfer cash to cost men who coordinated with Speaker Romualdez staff member Jocelyn Sereno for delivery to the Speaker's residences, etc., etc. Napakaraming factual allegations. Maniniwala ba tayo kay Ko? Kailangan po niyang bumalik dito para i-affirm niya under oath itong mga allegations. And we cannot simply dismiss them, set them aside, simply because he's now a fugitive from justice. Hindi natin gusto na fugitive from justice siya. Kailangan harapin niya yung mga pananagutan din niya bilang Appropriations Committee Chair and i-affirm under oath yung mga sinasabi niya. In addition to the 100 billion in insertions, ang isa po sa mga allegations, PBBM directed the insertion of another 50 billion. On December 2, 2024, 200 million was allegedly delivered, allegation lang po ito, was delivered to the PBBM's Forbes House. On December 5, 2024, another 800 million was delivered to the same house. Yusek Jose Cadiz delivered these sums to PBBM's house. That's an allegation. Another 8 billion in cash was delivered by DPWH Yusek Roberto Bernardo to PBBM through Yusecs Olaivar and Adrian Bersamin. These allegations by themselves are enough to establish the gravity of the charge so as to constitute the impeachable offense of betrayal of public trust and, of course, graft and corruption. When the impeachable official commits graft and corruption, necessarily he betrays public trust. This is the so-called nexus that is required for the Justice Committee to find an impeachment complaint sufficient in substance. Hindi pa po ito evidentiary. Hindi pa ho natin kailangan humarap dito si Zaldico ngayon sa hearing na ito. But in subsequent hearings, kapag maging sufficient in substance ito, itong complaint, the second complaint,
pag yung ating desisyon by majority vote ay ito ay sufficient, then we will require him to appear. Kung hindi siya mag-appear, hindi natin papansinin yung mga allegation niya. But right now, there are allegations. Ko, Bernardo, and then yung sa Cabral files. That's my point, Madam Chair. Hindi pa ito ang proceeding para patunayan kung totoo lahat yung mga kagimbal-gimbal na sinabi ng former Finance Appropriations Committee Chair. May tamang panahon para dyan. Pero hindi natin pwedeng sarado ang mata natin dito sa mga factual allegations. Sufficient factual allegations. The third ground, to me, is the strongest ground among the three grounds. Dahil may mga allegasyon na hindi ko, again, kailangan ko po talagang ulitin, hindi ko pa po sinasabi na naniniwala ako sa mga allegasyon. Pero gusto kong malaman kung totoo. At yun siguro ang gusto ng taong bayan, malaman. Totoo ba yung mga sinasabi ni Zaldico, ni Yusek Bernardo na nag-appear na sa Senado? Yun lang po ang punto. If the Justice Committee is to abide by its mandate and follow its own rules, the sufficiency and gravity of those factual allegations, including the others, in the complaint, and the nexus that they establish with the impeachment ground charge, which is betrayal of public trust. Kasi kung totoo mga yon, that is definitely and unquestionably betrayal of public trust. It necessarily calls for a finding of sufficiency in substance. Thank you.
Thank you, Honorable De Lima. The Honorable Keith Flores is recognized.
Thank you, Madam Chair. Madam Chair, a perusal of the complaint would probably show that the third ground is probably the strongest. And I would like to agree with Congresswoman De Lima that it is the strongest and may have a complete recital of facts about an impeachable offense. But we have to go back to the verification again, Madam Chair, that the information contained in the impeachment complaint must be true and correct based on their personal knowledge and on authentic documents. We already know that former Congressman Zaldico is not here and would probably not be able to validate the statements made on the video posted on social media. What then would stop any other person who is outside our jurisdiction from making statements against any of the impeachable officers that may implicate them in an impeachable offense and us continue proceeding with proceedings like this? It would just put them in a situation where indefensible because they could not cross-examine any of the witnesses who made those videos or maybe statements like that. But then again, that may have been the strongest ground in the impeachment complaint filed by the Makabayan. No? But it still cannot be substantiated, Madam Chair. It would be a total waste of time if we proceed with that, Madam Chair.
Madam Chair,
The Honorable Tino.
as was pointed out, and it is in the complaint, yes, there is a recitation of facts based on the statements made by Zaldico, but that is not the sole basis of the charge that the President directly participated in insertions and kickbacks. There is also cited the testimony, the sworn testimony of Yusek Roberto Bernardo. And in this case, he is not somewhere outside the country, he is right here. And he has appeared numerous times before the Senate at pwedeng-pwede pong ipatawag dito dahil siya rin, kumbaga, nag-confirm, nag-corroborate ang sinabi ni Zaldico sa sinabi ni Yusek Bernardo. No, kaya po, nananatili na merong malinaw na factual, na recitation of facts na nakabatay sa public records, including sworn testimony And therefore, may sufficiency in substance po ang pangatlong bahagi na ito na nagsasabing direktang inutos ng Pangulo ang 100 bilyong insertion sa 2025 budget at tumanggap ng kickback mula dito ayon mismo sa testimonya ni Jose Bernardo. Sufficient informed and substance. Thank you.
Statements made by Undersecretary Bernardo, but I do not remember any of the statement made by Yusek Bernardo directly linking the President to any of the acts mentioned. It may be corroborative of the statements of Paul, but I don't know if I just missed it, but I've never heard of Yusek saying directly that it was the President who told him, it was the President who received it, it was the President who directed them. It was always through some other persons or other layers po na sa statement niya. So with that alone, it would be very difficult to impute that crime of impeachable offense to the President himself because there are other people that are involved in the discussions made by Yusek Bernardo, Madam Chair. Madam Chair, just a very brief.
Verification of the complaint. The verification requirement states that the allegations therein are true and correct based on personal knowledge and based on authentic records and documents. The basis, the evidentiary basis of presidential involvement, personal, is Saldico confession. Saldico confession was made and published in a social media platform, ostensibly made outside of the Philippines, not based on authentic records. Second, Madam Chair, Roberto Bernardo testimony hypothetically admits that it was delivered to the office of the Executive Secretary, not to the office of the President. When we claim personal involvement, it's the Executive Secretary, even if we hypothetically admit that, because Bernardo testified in the Senate. Thirdly, Madam Chair, Cabral file. Until now, authenticity is being questioned. Even Secretary Vince Dizon denied the existence of any Cabral file. So this goes against the very basic requirement of the impeachment complaint as to form, which has to be verified. So that will be all. Mr. Chair. Thank you very much.
Mr. Chairman.
Representative De Lima first, before I recognize you.
Just a very brief comment about the contention earlier of the Honorable Representative Flores, the acting presiding officer now, na mahirap na sasama natin dito yung cause allegations or cause accusations dahil there's no opportunity to cross-examine him since he's not here. He's a fugitive from justice. All that the committee have to do is to issue the subpoena, summon him, and then give the chance, give an opportunity for him, the accuser, kung talagang seryoso siya, should end his fugitive from justice status. And pangatawan niya yung kanyang mga sinasabi by saying it
under oath. Hindi ko sinasabi na credible siya. Gusto ko lang marinig sa kanya at gusto natin siyang i-cross-examine para hopefully lumabas talaga ang totoo. Yan po ang punto. Allegations, factual allegations are here right before our very eyes. Nasa complaint. We cannot ignore them. Yun lang po.
Thank you, Representative De Lima. Congressman Abante.
Yes, Mr. Chair, I just would like to, I do not agree with the decision of the Supreme Court in dismissing the impeachment case against Vice President Sara. But at this point in time, in this impeachment proceeding against PBBM, I would like to agree with the statement of Justice Marvin Leonen. And I would like to quote what he said. He said, impeachment should never be abused to maintain the hegemonic dominance of greed by shaming those who occupy high government positions into preventing them into doing what they were sworn to do. This is why impeachment has been designed so that it is not merely a political process initiated by mere allegations, sabi niya, or by perceived public acclaim, shaped by the propagandistic effect of timed press releases or a responsible viral post on social media. Now, that is the statement of the Senior Associate Justice Marvic Leonen. At this point, Mr. Chair, as we talk about this impeachment of PBBM, I would rather agree with the statement of Associate Justice Marvic Leonen. Kanina po, palaging binabanggit yung hypothetical. Hindi ko alam kung naunawaan ng ordinaryo mamamayan natin ang ibig sabihin yan. But I would like to give a description of the meaning of the word hypothetical. It means imagine, suppose, or based on a suggested idea or theory rather than reality. Therefore, as I conclude, Mr. Chair, this discussion today, naniniwala po ako, all charges given here are speculative. They are not only allegations as admitted even by the respondent. They are allegations, but they are speculative and therefore they are also hearsay and therefore they are highly hypothetical and therefore the statement of Justice Marvic Leonen goes in tandem with the kind of impeachment that we are now doing against the President of the Republic. And therefore, to me, that is insufficiency of substance. Thank you very much, Mr. Chair.
Thank you, Honorable Abante. If there are no other members aside from the Honorable Po, then I wish to pronounce that we are about to end the deliberation. The Honorable Honorable Brian Po, and then Honorable Chua, and then Honorable Erice, one after the other. You're recognized.
Madam Chair, thank you for recognizing me. We cannot ignore these allegations, but they are exactly that. They are allegations po. We must allow the justice system to be able to conduct its investigations. No? We've had Infracom, we've had Blue Ribbon, we've had ICI, and if we move forward with this in substance, we will have another hearing yet again and invite the same stakeholders. The problem with doing so would be that you would also be taking away time from the investigation teams to conduct their investigations and file the proper cases. If the purpose of this is due process and to further justice and transparency, would it not be best to leave it to the DOJ and the Ombudsman to continue their mandate and actually continue with their investigation and their cases without being stifled with another hearing. But beyond that, let's also look at it on the grounds of what new information may come forward in a succeeding hearing should we give credence to the substance of this ground. Technically speaking, Madam Chair, if more cases are filed by the DOJ and the Ombudsman in the future, that would give more grounds for a healthier debate on impeachment. But as it stands, the investigation process has just begun for many of those who have been implicated in the previous hearings. So, Madam Chair, as it stands, it feels that the substance currently is subject to debate still. I feel that there's more that can be done if we trust the justice system that we currently have and trust the mandate of the DOJ and the Ombudsman. Just my 2 cents for the committee, Madam Chair.
Thank you. The Honorable Chua.
Thank you, Madam Chair. Madam Chair, while we have to admit that may point din naman po yung ating kasama, si Congressman Laila de Lima. But, Madam Chair, we have to also consider yung sinasabi po kanina ni Congressman Fortes, which is, I think, very logical din po. Dahil from the very beginning, kung may intention naman po si Congressman Saldico na makipag-ugnayan at makipagtulungan po sa atin, kahit naman po hindi siya pumunta dito, he could have sworn before the embassy kung nasaan man po siya ngayon. But the fact na wala naman po siyang sinasubmit, and in fact, mag-issue man po tayo ng invitation sa kanya, meron na nga rin po siyang outstanding warrant. Kung tama po yung pagkakaalam ko, meron din po siyang outstanding warrant. So, ibig sabihin, wala po talaga itong intention na makipagtulungan dito o magpakita sa atin. So, this will be an exercise in futility kung sa kanya lamang po tayo aasa. At yung pong sa sinasabi pong Cabral files, the only person who can authenticate that document, patay na po, si Yusek Cabral. So, doon naman po sa claim ni Yusek Bernardo, wala naman po doon binabanggit or direct link na masasabi po natin na binabanggit about the President. So, having said that, tingin ko po, kulang pa rin po talaga ito dahil maliwanag naman po, kailangan po talaga authenticated ang document or may personal knowledge po. That is only my view, Madam Chair.
Thank you. Next in line is the Honorable Erice.
Thank you, Madam Chair. Inuulit ko po na naniniwala po ako na may sufficient basis, may sufficient substance ang nasabing complaint ng Lisa Maza Group. At naniniwala po ako na napatunayan nila sa kanilang mga manifestations na tuwiran po na ito lang ang paraan natin para mapanagot ang mga impeachable officials. At ito po yung ating Pangulo. Hindi natin sinasabing guilty na ang Pangulo, ang sinasabi lang po natin, may batayan para tayo ay magpatuloy ng investigasyon dito sa community na ito. Factual po yung kanilang mga sinasabing mga pangyayari. Ito po ay may malaking epekto na nangyari sa ating bansa. Dahil sa pagpayag ng Pangulo, pagpapabaya ng Pangulo sa 3 budget, nanakaw po yung pondo natin, napunta sa mga flood control projects. At sa palagay ko po ay napatunayan nila yung na meron po talagang substance yung kanilang reklamo. Yung usapin po ng substance ay kasama po sa regulations, sa rules and regulations natin. Yung parameters po ng determination ng substance ay maliwanag ayon sa ating rules. At ayoko po sana mangyari, pero kung basta na lang po natin babaliwalain yung substance nito, maaari na naman pong makarating ito sa Korte Suprema. Maaari pong makarating muli ito sa Korte Suprema sapagkat ito po ay, ang batayan dito ay yung nakasunod ba ang committee na ito sa rules and regulations ng impeachment process. Salamat po.
Thank you, Honorable Erice. While we value the significance of the statement, which sounds like a closing statement, we wish to remind the members of the Justice Committee that we are on the deliberation of the third offense, that is direct personal involvement in budgetary insertions and kickback schemes. Now we recognize the Honorable Rodriguez.
Thank you, Madam Chair. The third act of betrayal of public trust is stated on page 27, which says the important words here are direct personal involvement in budgetary insertions and kickback schemes. Madam Chair, if you look at the particulars, there are three evidentiary streams that they have said, which is part of the recital of facts. First, the Saldico confession. Second, the Roberto Bernardo testimony, and then the Cabral files. So, from this recital of facts, we can already see that the Cabral files cannot be a basis of an impeachment because it has not been stated, authenticated, no statement here that the Cabral files is a source of authenticated documents that has been accepted even by the department, because Secretary Vince Dizon has already debunked this particular file, which has OPES SAP. And so therefore, this statement here that this is a direct evidence of presidential involvement cannot stand. The third one cannot stand. The Cabral files is a file and it has not been authenticated. There is no statement here that these Cabral files is admitted to by the one who made the file. So therefore, there is no basis for this. The second one, Madam Speaker, Madam Chairman, is the Roberto Bernardo testimony. It states here, confirming the delivery of 8 billion in kickbacks via armored vehicles, armored vans, to the office of the Executive Secretary. There is no statement here that is delivered to the President because they are alleging in their charge that it should be, there is a direct personal involvement in kickback schemes. So therefore, the second ground has no basis. We cannot connect, there is no connection. Delivery in the office of the Executive Secretary is not even office of the President. And so therefore, this one has no leg to stand on. Now, we go now to the only evidentiary, according to the complainant, the only evidentiary nature to me that recites some facts of direct involvement. What is this? Direction of Saldico to direct the President or directly to have the 100 billion insertion, and then the personal delivery of 1 billion. Madam Chair, the problem with this sole evidence, according to them, to link the President to kickbacks and insertions, the problem with this sole, the only one that directly implicates the President, is coming from a polluted, fugitive source, not under oath. And any document that is not under oath, not before a notary, not before the Philippine Embassy, there can nothing that can spring from any video presentation. There is nothing. It cannot be a source of, especially of this complaint against the President. Because it is a video statement, not under oath. And the person is extraterritorial. He's not in the territory of the Philippines. So therefore, Madam Chairman, the saldico confession, the sole evidentiary stream that they stated, which says that the President ordered the insertion and the President also ordered the personal delivery to his residence. They can never be used in any pleadings, especially in the pleadings for a complaint for impeachment. It cannot be, for those reasons I have stated. It is hearsay, it is nothing, it is absolutely a waste of a statement, and his video is a scrap of video. Now, we go now to the statement of the cover-up resignations without. They are saying that why were they not investigative prosecution? That will go there. It is something premature for them to state. So this cover-up has no basis. D, the President Public Admissions and Evasion. In fact, the SONA already said, mahiya naman kayo. Because of these flood control issues, and then later on, he presented the 15, the list of 15 contractors, cornering so much of the budget. So the admission, the president, he was the one who exposed all of this. And then here we go, the last one. The legal standard. Okay, let's go to the legal standard. Madam Chair, under the law, according to the complaint, a superior officer can be held criminally liable for the acts of subordinates because there's no such thing as command responsibility. It has to be some personal culpability. If these three, according to them, and she's correct, based on the Supreme Court cases, what are these? One, the President had effective control over the subordinates. Correct. Number one is right. Number right. First one is correct. They are all subordinates. All of these officials, executive secretary, public courts, and so forth. But here, the second one cannot be. There's no statement of fact to support the next one. He knew or should have known the subordinates' unlawful acts. What is the statement? That he knew. What is the recital of fact here? That he knew the subordinates' unlawful acts. Nothing. And then the conjunction and. In other words, 1, 2, 3 should be and, not or. So therefore, and the third one, he failed. Marcos failed to prevent or punish his acts. Where is the statement of facts that he failed to prevent or punish this act, which has nothing to do at all? And so therefore, Madam Chair, the legal standard of command responsibility and personal culpability does not exist for the failure of the two other requirements. Now we have the legal conclusion. Once again, we cannot discuss this because they cannot have a legal conclusion. Therefore, Madam Chairman, clearly, the third charge is likewise insufficient in substance. Thank you, Madam Chair.
Thank you, Honorable Rodriguez. Next is the Honorable Janice Digamo. And then the Honorable Vice Chair Dumogan. Did you raise your hand, Kong?
Madam Chair, after hearing everyone and going over the Maza grounds, the third ground, I would like to recognize our legal luminaries like Ma'am Laila, Attorney Jokno. But hearing what Kong Rufus also have said, I believe that the third ground relied so much on media reports, raised corruption concerns. However, it failed to show direct presidential acts with proof. Kaya sa paningin ko po, it is insufficient in substance. Thank you po.
The Honorable Vice Chair Dumogan.
Thank you, Madam Chair. Yes, we cannot deny that we have these anomalies that have been discovered, and it cannot also be denied that it was because of what the President had done, stating it in his SONA, creating an investigative body, as well as tasking the Department of Justice and the Ombudsman that a lot of those involved are now facing criminal charges. And investigations are going on. It is not fair to allude to the President that he said this in the SONA just to distance himself from the said corruption. That is not fair. And considering all those that had been said, unfortunately, even on this third ground, there is no direct evidence that will justify the filing of an impeachment against the President. It has been clearly elaborated. The statement of Yosek Bernardo, which does not link the President directly. The confession of Saldico, who is a fugitive from justice, which is not under oath, which is, of course, under our own rules. We cannot base the assessment of sufficiency and substance by just disregarding the basis of authentic records. So in its totality, Madam Chair, there is no sufficiency and substance even in on this third ground.
Thank you, Vice Chair Dumogan. Are there any other members who wish to make a manifestation? Hearing none, the Chair declares our deliberation on the sufficiency in substance of Maza et al. Impeachment complaint terminated. We have come to the point of voting. And for the guidance of all the members, we will be voting first on the De Jesus impeachment complaint. Thereafter, we will be voting on the Maza et al. Impeachment complaint. For the guidance of everyone, let us all be reminded, both have been declared already as sufficient in form. And our voting this afternoon is on the determination of sufficiency in substance. Before we proceed to voting, the Chair wishes to address the Justice Committee. We recognize the knowledge, expertise, and wisdom of all the members in this extensive and exhaustive deliberation in the De Jesus impeachment complaint and Maza et al. Impeachment complaints determination of sufficiency in substance. The Chair purposely became very liberal in hearing the members' comments and even questions and answers. This is in recognition of the extraordinary power of the sovereign Filipino people to impeach high-ranking official if they are liable to the law. As representative of the sovereign people, we are likewise their voice. And it is incumbent upon this committee to ventilate all possible views and opinions of the people whom we represent. Likewise, the extensive and exhaustive deliberation provided better and wider perspective as we come to the end of our deliberation. Mga kasama, before we vote on the sufficiency in substance of the De Jesus and Maza complaint, the Chair would like to remind everyone of the immense weight of the task at hand of this committee. Sa pagtukoy kung may sapat na substance ang mga reklamong ito, laging kinikilala ng komite ang sound discretion ng bawat miyembro. Your vote must be rooted in your individual appreciation of the facts, the allegations, and the annexes attached to the complaints. Although the rules of procedure on impeachment proceedings state that the requirement of substance is met when there is a recital of facts constituting the offense charge and determinative of the jurisdiction of the committee, huwag nating kalilimutan, impeachment is a sui generis proceeding. It is a class of its own. Hindi lang ito basta legalidad. Ito ay usapin ding politikal at moral. Uulitin ko po, ito ay isa sa pinakamakapangyarihang mandato na ibinigay sa atin ng Konstitusyon. The 1987 Constitution has lodged this power in us, the members of Congress, who are duly elected representatives of the Filipino people. It is our duty to determine whether or not the highest officials of the country have committed acts that are so detrimental to the Filipino people that they deserve to be removed from office. Kaya naman, I urge every member of this committee, vote not out of convenience. Vote with your conscience. Isipin natin ang kapakanan at kinabukasan ng bawat Pilipino. Let us prove that in this hall, the interest of the Filipino people always comes first. Maraming salamat po.
Madam Chair. Madam Chair. Madam Chair.
The Honorable Nisa is recognized.
Before we vote on the De Jesus complaint, I would like to have a manifestation.
We recognize the Honorable Nisay for the purpose of his manifestation.
Point of order, Madam Chair.
What is the point of order of the Honorable
I'd like
Abante?
to add, what is the purpose of the manifestation when he already spoke a lot of things?
Let us be
during the
reminded
time?
that the Honorable Nisay is the endorser of the De Jesus complaint.
I do
So
realize that, Madam Chair.
the committee would like to accord.
I just would like to ask, what is the purpose of this manifestation? What
Would you
is
like
the
to
purpose?
answer the question of the Honorable Abante?
To explain the arguments and the
Madam
closing
Chair,
statement.
that has been so
and the closing
explained.
statement.
Perhaps, Honorable Nisay, you just make a quick closing statement in support of the sufficiency in substance of De Jesus complaint.
Thank you, Madam Chair.
You may proceed.
Madam Chair, we respectfully reiterate, hindi pa po ito trial on the truth. Ulitin ko po ang relevant portion, Section 5 ng Rule 3 ng ating House Rules. The requirement of substance is met if there is a recital of facts constituting the offense charge and determinative of the jurisdiction of the committee. Ang proceedings natin ngayon ay masasabing nasa pleading level pa lamang. At ito ay dapat tumatalakay muna kung ang complaint ay may recital of ultimate facts at ang ultimate facts na ito ay maaaring mga acts, omissions, at inactions na may kasamang konteksto na kung i-assume natin na totoo sa ngayon ay magko-constitute talaga ng impeachable offenses. Keeping in mind that standard, I am respectfully submitting ng mga narinig kong manifestations ng dahilan ng substance insufficiency kahapon para rito sa De Jesus complaint ay mainly nagre-revolve na sa appreciation of evidence at ultimate truthfulness ng mga aligasyon. With all due respect, hindi pa po ito ang panahon ng paglilitis. Paulit-ulit ang ating Honorable Chair kahapon, ito ay preliminary stage pa lamang. Hindi lang din ako ang taong dapat sumagot dito. May complainant na nakapirma at nag-verify ng complaint na hindi pa naman naiimbitahan sa mga initial na pagdinig na ito. At this stage, the question is narrower. May facts alleged ba? May context ba? At may clear nexus ba to an impeachable ground? Sa unang argument o offense, Madam Chair and honorable members of the committee, sufficiency in substance that not require na may existing criminal charge already filed against the respondent, nor that the pleading uses the perfect criminal law label of kidnapping. Gaya ng mga tanong na ibinabato sa akin kahapon, ang recital of facts sa complaint na ito ay ang inaksyon ng presidente at hindi ng kung anong executive orders mula sa presidente. Maliwanag, Madam Chair, for this offense, the complainant narrates inaction kaya clearly may recital of ultimate facts. Hindi lang ito conclusions. Dagdag pa, these pleaded facts are attributable to the impeachable officer. Dahil nabanggit ko, may mga command responsibility ang ating Pangulo over through PNP. At assuming that these pleaded facts are true, then the allegation may constitute the culpable violation of the Constitution. Sa ikalawang argumento, napansin ko ho na ang mga tanong na ibinabato sa akin muli ay nagdedelve sa katotohanan o merito ng mga alugasyon. Inuulit ko po, ang tinutukoy na recital of facts ay ang inaksyon ng Pangulo na nagbibigay ng malinaw at maayos na kasagutan sa aligasyon ng paggamit
If I
umano.
may interrupt the Honorable Nisay, kindly shorten your closing statement. You've been given an ample opportunity during the deliberation of the sufficiency in substance of the De Jesus complaint. Kindly shorten your closing statement.
With all due respect, ito ay depensa na ng respondent at hindi ng mga members of the committee. Hindi pa po ito ang tamang panahon upang atakihin o pabulaanan ng recital of facts sapagkat inuulit ko, tayo ay nasa preliminary stage pa lamang ng proseso. Dagdag pa rito ang simpleng drug testing, particular na rin ang hair follicle drug test na matagal nang pinananawagan ng sambayanan ay nananatiling hindi maisagawa ng Pangulo. Kung tunay na nating inaasahan ng pinakamataas na pinuno ng bansa ay magsisilbing ehemplo lalo na bilang lingkod bayan, ang ganitong panawagan sana ay madaling tugunan upang alisin ang alinlangan at mapanatili ang tiwala ng publiko. Maliwanag, Madam Chair, for this argument, the complaint narrates another inaction which almost amounts to admission na mayroong naging illegal drug use ang Pangulo. Clearly, mayroong recital of ultimate facts, hindi lang ulit ito conclusions, at assuming that this is true, then the allegation may constitute betrayal of public trust na isa sa mga impeachable grounds. Sa ikatlong argumento naman, with all due respect, the absence of mandatory legal duty does not automatically erase an allegation from the realm betrayal of public trust. The Constitution recognized that some acts are short of being criminal but may still be serious breach of public trust when attended by bad faith, gross faithlessness, or gross misuse of discretion. Nakasaad po dito sa aking paunang speech kahapon na hindi namin dinidispute ang katotohanan na wala nga naman talagang legal duty ang presidente na magbito. Ang moral aspect din ang ating tinitingnan dito. Kung ating susuriin ang national budgets, mapapansin na lumobo na ang mga program appropriations at record high kumpara sa mga nagdaang mga administrasyon. Sa makatuwid for this third offense, the complaint narrates on an omission of the part of an impeachable officer.
Honorable Nisay, I am aware that you have 5 offenses. You are on the third. Kindly shorten your closing statement.
Madam Chair, kung nakakalimutan natin na ang power to impeach ay parte ng ating checks and balances, kung sa umpisa pa lamang ay tila ipinagtatanggol na ang Pangulo, ano pang silbi ng checks and balances na ito? Huwag sana nating gawing mas komplikado ang sufficiency in substance. It was meant to be simple and workable because impeachment is the Constitution mechanism to ensure accountability of impeachable officers. Kapag may seryosong aligasyon at red flags, hindi natin pwedeng sabihing bahala na. Kapag may seryosong aligasyon at red flags na nagiging pattern na, hindi natin pwedeng i-technical ang private citizen na dumudulog sa atin. Hindi tayong pwedeng magbulag-bulagan sa mga hinaing ng ating mga kababayan na mas malubhang naapektuhan at mas maapektuhan ng mga aligasyon na ito. Dahil katulad ko, alam ko ang bawat isa sa inyo ay nakikita rin ng mga ito. Ang gusto lang din naman ng taong bayan ay buksan natin ang pinto ng proseso at dinggin ang kanilang mga hinaing. Madam Chair, in view of the foregoing, I respectfully submit that the impeachment complaint be deemed sufficient in substance and that it accordingly be allowed to proceed to the next stage of the proceedings. Maraming salamat po, Madam Chair.
Because we gave opportunity to Representative Nisay to make a closing statement in support of the Jesus impeachment complaint, in the interest of equality, we are giving as well the same opportunity to the endorsers of Maza et al. Impeachment complaint. The Honorable Tino.
Madam Chair, we will give the 3 endorsers, but I think we are now ready to vote on the first one.
How many endorsers will be delivering a closing statement?
3. Pero
Three?
maiksi lang po,
Yeah,
Madam Chair.
that's okay. The 3 can speak. But let us now vote because we're finished through already with the first one so that we can already decide on the first one after hearing the closing statement.
Honorable Rodriguez, the chair wishes to do the voting one after the other, immediately one after the other. So I wish to request Honorable Tino only to deliver the closing statement.
Chair, I wish to state that I always agree with the chair.
Thank you, Honorable Rodriguez.
Madam Chair, you said only.
Will Honorable Co and Honorable Ilago be amenable to that? That it will only be Honorable
Only.
Tino who will be delivering the closing statement in support of the, or you can choose who among the 3 of you.
To my understanding, Madam Chair, the motion provided by Honorable Rufus is that we vote first on the first complaint. And then
He withdrew his motion already because he said he's always following the chair.
Okay. We'd still like to provide a short manifestation if possible, Madam Chair.
Yes, please, but we will be allowing only one endorser in support of Maza et al. Complaint. This is only in the interest of equality
Sige
because
po.
we heard the closing statement
Okay.
of the Jesus impeachment complaint. Honorable Tino, you're recognized.
Maraming salamat, Madam Chair. Bumoto ang committee ito na sufficient inform ang Maza et al. Complaint. Ibig po sabihin, verified complaint na nakabatay sa personal knowledge and authentic records. Kaya settled na po ang usapin na ito, no, as far as this stage of the proceedings is concerned. Narito tayo ngayon sa determination of sufficiency in substance. At ang kinakailangan lamang po rito ay tiyakin na merong recitation of facts na nagpapatungkol sa isang ground for impeachment at therefore dapat na maging patuloy na paksa ng komiting ito. Malinaw na palinaw po na sufficient in substance ang Maza et al. Complaint. Meron pong malinaw na ground, betrayal of public trust, laban kay Pangulong Bongbong Marcos Jr. at malinaw din po ang recitation of facts na pinagbabatayan nito. Una, yung institutionalization ng formula para sa preparasyon ng National Expenditure Program na sinabmit ng Pangulo sa Kongreso sa 3 taon ng kanyang presidency, no? At ito ang sistema na punot dulo ng flood control corruption scandal. Yun yung tinatawag nating PBBM parametric formula na karugtong ng mga sistema ng mga proponent o modus ng mga proponent, commitment or kickback mula sa mga corrupt na contractor tungo sa mga corrupt na opisyal. No? Pangalawa, sinabi dito as a relation of facts na inabuso ng Pangulo ang kanyang discretion sa paggastos ng budget, particular sa unprogrammed appropriations. Kung ang una ay sa preparasyon, ang pangalawa ay sa implementasyon o paggastos ng budget. Malinaw na binanggit, ni-recite sa complaint na tangi, sole and exclusive ang discretion ng Pangulo sa paggastos. Kung ano ang paggagastusan at kung ano ang hindi paggagastusan ng unprogrammed appropriations, at inugnay natin ang pinaggastusang ng unprogrammed appropriations na inaprubahan ng Pangulo mismo, direktang at personal, sa corruption. No? At kasama rin dito sa abuse ng kanyang discretion ang pagpahintulot na gamitin ang PhilHealth funds para sa infrastructure kahit alam ng lahat na ang pondo ng PhilHealth ay ayon sa batas, PhilHealth law at saka laws on sin taxes, hindi pwedeng gamitin para sa ibang purpose kung hindi para sa kalusugan. No? At panghuli ay sinasabi dito na direktang may paglahok sa insertion at pagdanggap ng kickback ang Pangulo. No, sa madaling sabi, sufficient in substance po ang complaint at ang pinakamahalaga po dito ay sinasagot ang tanong. No? Nangyari ang pinakamalalang corruption na tinatawag nating flood control corruption scandal sa unang 3 taon ng pagkapangulo ni Ferdinand Bongbong Marcos Jr. Ang tanong ng lahat, alam ba to o hindi alam ng Pangulo na nagaganap ang ganitong corruption? No? Sinasagot po ng complaint, sinasabi dito, hindi lang sa alam niya, kung hindi siya ang nagpahintulot at may direktang partisipasyon sa corruption na ito. Ito ay pagtataksil sa tiwala ng taong bayan at therefore dapat siyang ma-impeach.
The Chair declares the termination of all forms of statements and manifestations. We shall now proceed to vote. The Chair is ready to hear the motion for the declaration of sufficiency in substance of the De Jesus impeachment complaint.
Madam Chair,
The Honorable Zamora is recognized.
Madam Chair, I move to declare the De Jesus complaint insufficient in substance. Insufficient in substance.
There is a motion to declare the De Jesus complaint insufficient in substance. Is there a second?
Second.
The same has been seconded. Is there any objection? May I ask, Honorable Nisay, if you are a member?
Yeah, member. I'm a member.
Are you a member of the Justice Committee?
Ex officio member. Deputy
Okay.
minority.
As an ex officio member, then he has the right to vote. And
I
even to raise a motion.
I object, Madam Chair.
There is a motion to declare the De Jesus impeachment complaint insufficient in substance. The same has been objected to. We therefore divide the House. Again, the motion is to declare the De Jesus complaint insufficient in substance. Those who are in favor of the motion, please raise your right hand. You may put down your hands. Those who are not in favor of the motion, please raise your right hand. You may put down your hand. Those who abstain, please raise your right hand. You may put down your hands. With a vote of 42 in favor of the motion, 1 against the motion, and 3 abstain, the chair therefore declares the impeachment complaint of De Jesus insufficient in substance. At this juncture, the chair is ready to hear the motion for the declaration of sufficiency in substance of Maza et al. Impeachment complaint.
Madam Chair.
The Honorable Erice is recognized.
Madam Chair, I move that we declare the Maza complaint as sufficient in substance. So move, Madam Chair.
There is a motion to declare the Maza et al. Impeachment complaint sufficient in substance. Is there any second?
Second the
Who
motion,
seconded?
Madam Chair.
The Honorable De Lima seconded. Is there any objection?
I object.
The motion has been objected to. We therefore divide the House. Let me restate. The motion is to declare Maza et al. Impeachment complaint sufficient in substance. Those who are in favor of the motion, please raise your right hand. You may put down your hands. Those who are not in favor of the motion, please raise your right hand. Okay. You may put down your hands. Those who abstain, please raise your right hand. With vote in favor of the motion, 7, and those against the motion, 39. with 0 abstention. The chair declares the Maza et al. Impeachment complaint insufficient in substance. That concludes the voting on the sufficiency or insufficiency of substance of the 2 impeachment complaints. If we have no other matter to discuss, we are suspending the meeting until February 9, 2026, 10 o'clock in the morning. Members present are considered informed in today's hearing. Meeting is suspended.